Weekly list item number 12.
May I please, Your Lordships? The supplicant has been convicted by the Lord Additional Session Judge, convicting the appellant under Section 302 and sentencing him to undergo RI
You
for
have
life.
mentioned in your note of argument
Sorry,
307.
my lord, sorry.
It's 302.
Sorry. To undergo RI for life and pay a fine of rupees 10,000. In default, to undergo RI for 1 year, 1 year more.
No, we'll go through your note, but first place the FIR. Let us know.
Yes, my lord. FIR is exhibit.
Page 25.
Running page 25, exhibit 2. May I read?
Yes.
ମହାଶୟ ଲେଖିବାକୁ ଜଣାଉଛି କାରଣ ଏଇ ଯେ ମୁଁ ଶ୍ରୀ ଅଗସ୍ତୁସ ଏକା ପିତା ସୋନସୋ ଗ୍ରାମ ସୋନସୋ
Is PW?
is PW3
Okay.
ଅଦ୍ୟତା 2/11/2003 ଦିନ ଆପଣଙ୍କ ପାଖରେ ଏହି ରିପୋର୍ଟ କରୁଅଛି। ଆଜି ସନ୍ଧ୍ୟା ସମୟରେ ଆମ ଗ୍ରାମର କବର ପର୍ବ ପାଳନ କରୁଥିଲୁ। ଆମ୍ଭେ ଗାଁର କବର ସ୍ଥାନ ଠାରେ ପୂଜା କରୁଥିଲୁ। ପ୍ରାୟ ରାତ୍ର 8 ଘଣ୍ଟିକା ସମୟରେ ଆମ ଗାଁର ସ୍ୱର୍ଗତ ସୁଶୀଲ ଏକା ଘର ଆଡୁ ବହୁତ ଜୋରରେ ପାଟିତୁଣ୍ଡ ଶୁଣାଗଲା। ମୁଁ ଗାଁର ମୁଖିଆ ହିସାବରେ ଅନ୍ୟମାନଙ୍କ ସାଥିରେ ସୁଶୀଲ ଘରକୁ ଗଲୁ। ଦେଖିଲୁ ସୁଶୀଲ ଏକାର ସ୍ତ୍ରୀ ଲରେନ୍ସିଆ ଏକା ଗୁରୁତର ଭାବରେ ତା ଦେହରେ ଆଘାତ ଡିସିଜ୍ ମାରିଲା।
Okay.
ଲରେନ୍ସିଆ ଏକା ଗୁରୁତର ଭାବରେ ତା ଦେହରେ ଆଘାତ ହୋଇ ରକ୍ତାକ୍ତ ଅବସ୍ଥାରେ ବଚାଅ ବୋଲି ପାଟି କରୁଛି। ମୁଁ ବୁଝାବୁଝି କରିବାରେ ତାର ଦିଅର ମାରିଆନ୍ସୁ ମାରିଆନ୍ସୁ ଏକା ଓରଫ କତ ତାକୁ ଘର ଗଣ୍ଡଗୋଳ ନେଇ
The appellant is the brother-in-law
ଦିଅର
of the deceased, right?
Yes, madam.
Okay, ଦିଅର, ହଁ. Yes.
ଘର ଗଣ୍ଡଗୋଳକୁ ନେଇ ଗୋଟିଏ ଭୁଜାଲିରେ ଗୁରୁତର ଭାବରେ ମାରି ଆଘାତ କରିଛି ଏବଂ ତାକୁ ଜୀବନରେ ମାରିଦେବାକୁ ଚେଷ୍ଟା କରିଥିଲା, କିନ୍ତୁ ଗାଁ ଲୋକ ପହଞ୍ଚି ଯିବାରୁ ସେ ଦୌଡ଼ି ପଳାଇଗଲା। ଏହି ଆଘାତରେ ଲରିଆନ୍ସର ପେଟରେ, ହାତରେ, ବେକରେ ଏବଂ ଅନ୍ୟାନ୍ୟ ଜାଗାରେ ଗୁରୁତର ଭାବେ ରକ୍ତ ବାହାରୁଥାଏ। ତାର ଏପରି ଅବସ୍ଥା ଦେଖି ଆମେ ଗୋଟିଏ ଟେମ୍ପୋ ଠିକ୍ କରି ରାଜାପୁର ହସ୍ପିଟାଲକୁ ଅତି ଶୀଘ୍ର ତାର ଚିକିତ୍ସା ପାଇଁ ପଠାଇଲୁ। ଏହି ଘଟଣାରେ ମାରିଆନ୍ସୁ ଏକା ଦୋଷୀ ଅଟେ।
So, the case was registered on 2/11/2003.
Yes, my lord.
And offense
341, 326, 307.
Okay. So when the deceased died?
The IO got information on 4/11/2003. Thereafter, the case has been turned to 302.
So death is on 4.
4.
4.
Actual date and time is not known, my lord.
No, he died at which hospital?
On RGH, Raulkela. She was first she was taken to Government Hospital Rajgangpur. From there, she was referred to RGH Raulkela.
No, the PM was conducted on which date?
PM was conducted on 4. Yes, my lord.
Okay. So, ଘଟଣା ହେଲା 2/11/2003 ହେଲା।
ଆଜ୍ଞା।
So, death news received on 4/11/2003.
Yes, ma'am.
Okay. And PM also on the same day?
On the same day.
Okay. Now, just tell us that whether it's a case of eyewitness or circumstantial evidence.
Although, my lord, the trial court has taken PW8 as the eyewitness, but as per the evidence of PW8, he's not
go to that. Just tell us. You'll argue
basing on the circumstantial evidence that to the
first tell that one eyewitness is there, that is PW8.
PW8.
Okay. Then what are the eyewitness account has been believed by the trial court?
Yes, ma'am.
Okay. Then what else are there in the
oral
deceased? The
oh,
deceased was shifted from the uh, spot to the hospital,
hospital
and she died after 2 days.
after
almost.
2 days.
So during course of which she made dying declaration.
Dying declaration. And also in the house, she has given dying
Okay, so
oral dying.
oral dying declaration before which
PW3,
PW3,
4,
okay,
5,
yes,
6,
hmm.
8.
These are the witnesses.
11, 12.
They are all.
11, 12, they were the witness to the oral dying declaration, which she has given in the hospital at
No, no,
RGH Mala.
it's all right. Just tell us the total number of
Total number
PW11, then
12.
12.
Yes,
And PW 10, doctor.
Okay, doctor has recorded it.
recorded
Yes.
it.
I see. Okay, PW10, doctor recorded. Then this 3, 4, 5, 6, 8,
Yeah,
they have stated about the dying declaration at the spot.
it is
Okay. And this 11, 12, they have stated in the hospital.
hospital.
Apart from that, the doctors recorded.
Doctor or medical officer of Rajgangpur Government Hospital, he has
Okay.
recorded it.
Acha, these are then anything else about the leading to discovery of
Yes, my lord.
who has stated?
PW4.
What was recovered?
At the instance of the appellant, a Bhujali has been recovered
Ujali was recovered. Okay.
and the wearing apparels which he has concealed in his house.
Wearing apparels, his own wearing apparels.
Own wearing apparels.
With blood stain.
Bloodstain. Okay. Those who are sent for
Chemical
examination.
examination and found that the human blood.
A C report also indicates blood in the Bhujali,
Bhujali and Ganji.
the bloodstain, that wearing apparel.
Wearing apparels.
Okay, that C report has been marked as
C report has been marked as exhibit 16, my lord.
16.
16.
Okay, the seizure aspect has been stated by PW4, the independent witness,
Yes, my
and
lord.
of course the IO.
Yes.
IO is
IO, my lord, he is not examined because by the time the trial starts, IO is expired, my lord.
Okay, then who has any other police
The
officer?
yes, my lord,
PW13.
the IIC PW13.
Okay, PW13, the IIC, and PW4, the independent witness.
Yes.
Right.
Yes.
So these are the evidence against the appellant or anything else is
Sure.
there. These are all.
Yes, ma'am.
So before going to that, let us see that doctors that
PW10.
PM report.
PM report PW7.
Along with that PM
PM doctor PW7.
Okay, PW7 is the PM doctor. What is the page number?
Page number 43.
So he conducted PM on
4/11.
2000.
And you are the assistant surgeon, subdivisional hospital,
Panpos.
right?
Yes.
So the first wound is on the left forearm. Second is left axilla. Third is right clavicle. Fourth is on the pinna of the right ear.
Right temporal.
Right temporal region. So then fifth is elbow joint, no?
Yes.
That is right upper arm. Okay. So six is adjacent
Adjacent
injury
to
number
injury
five.
number 5.
7 is left knee joint.
Left leg.
8 is left scapula.
Scapula.
9 is left
Buttock.
buttock. 10
10
is
is left lower.
lower region of the abdomen. Antemortem in nature. Okay. And cause of death, shock and hemorrhage due to extensive injuries described in so and so. All the injuries are sufficient to cause death in ordinary course of nature. I examine one Bhujali. Bhujali is the weapon of
Yes,
Yes, my
occupation.
lord.
Who find that the injuries found on the person of the deceased as per so and so is possible. Okay. All right. So now we'll go to one by one. That is first, let us say that eyewitness. Come to that. That is
PW8.
PW8.
That is in page 46, my lord.
Yes. Please place the evidence of it.
My lord. I know the accused and deceased. They are my neighbors. On 2/11/2003 at about 8 p.m., when I was in my house with a small child and my family members have gone to the graveyard for performing the customary worship, I heard sound from the house of the accused and deceased. Hearing the sound, I went to their house and saw in the courtyard that the accused was holding the deceased. And on my arrival, the accused left the deceased and ran away. The deceased fell down, and I marked bleeding injuries on her neck, belly, arms, legs, etc. When I asked the deceased, she told that the accused had assaulted her by knife. Thereafter, villagers arrived, and the deceased disclosed before them that the accused had assaulted her. The victim was shifted to Government Hospital, Rajgangpur, and therefrom she was referred to RGS Raulkala, where she succumbed to the injuries after 2 days.
No, so this actual assault he has not seen.
Not.
No.
The accused was present with the deceased, and number two,
And
the
oral dying.
oral dying
Oh.
contraction, right? So told that so and so. Villagers also arrived, and before them also accepted. Then government hospital Rairangpur. Then to IGH Raurkala, where she succumbed to the injury. Okay, and there is no cross examination.
No.
Yes, man.
So
Cross examination.
not see, he has not stated in the chief, so there was no necessity of putting this question.
Yes, man.
So dying declaration, presence of the appellant with the deceased has remained unchallenged.
Yes.
Okay. PW8. PT, presence of appellant deceased. Challenged. Okay. Now, let us come to the dying declaration.
PW3.
3. Okay,
Yes.
right.
Page 36.
On
Yes.
I know the accused as well as the deceased. On 2/11/2003 at about 8 p.m., when we had been to the graveyard for some customary worship, we heard a hue and cry from the village side, and I, along with some other villagers, came to the village and saw that the deceased Laurencia, the daughter-in-law of Vincent Eka, was lying in front of her house with bleeding injuries on her belly, neck, and head. She was alive at the time of at
At
that
the
time. Being asked by me, she told that her brother-in-law Marianus has assaulted her by a knife. At that time, Marianus was not present. And second one, thou the deceased and the accused were living in one house, but they were separate in mess. They were not pulling on well. The son of the deceased, namely Sushanta, had also told me that he had seen the accused running away from the spot after the occurrence. We made arrangement for shifting Laurentia Eka to the hospital for treatment. Thereafter, I prepared a written report which
This Shanta is PW5.
PW5 is the minor son of the deceased.
Okay.
Thereafter, I prepared a written report which was lodged at the PS. Exhibit 2 is that FIR written by me, and Exhibit 2/1 is my signature thereon. Later, I came to know that Laurentia had been referred to IGH Raulkela for better treatment, where she died. In the cross-examination, I had not gone to the PS to lodge the FIR. House of Dharmadas and Sanjay Topo are near the house of the deceased. The deceased was staying with her mother-in-law and children. The distance of the house of the deceased and the graveyard where we had gathered for prayer is about 100 meters. I cannot say who else was present with me at the time of prayer. Laurentia, then again here he said that Laurentia was lying in the courtyard. But in the chief, he has stated that Laurentia was lying in front of her house. And
it's not a material discrepancy.
in this poem, the exact place could not be proved because.
Yes, continue. Yes.
And by the time we reached there, Dharmadas had arrived. The deceased had also disclosed before me the reason of assault. Her son Sushant told me that he had not seen the occurrence, but had seen the accused running away. The parents-in-law and children, apart from others, were present when the deceased disclosed me regarding the assault. It is not a fact that no such occurrence has taken place, and I am deposing falsehood.
Next, PW
4.
He is also a neighbor of the deceased. I know the accused and deceased. On 2/11/2003 at about 8 p.m., we had been to graveyard for some customary prayer. After returning from prayer, we saw Laurentia Eka lying with bleeding injury on her person in the courtyard of her house. She had sustained injuries on the belly, neck, and hand, etc. And in total, she had sustained 9 injuries. Being asked, Laurentia disclosed that the accused had assaulted her by means of a bhujali. The parents-in-law of Laurentia, with the help of others, carried her to the hospital by a tempo for treatment. The victim was shifted to RGS for better treatment, where she died after 2 days. The matter was reported at the PS after the victim was sent to the hospital. I had been to RGS Raulkela to see the victim. By the time I reached there, she had died. Police had inquest over the dead body at RGS Raulkela in my presence and prepared inquest report. One Albinus Lakra was also present there. Exhibit 3 is the inquest report prepared in my presence, and Exhibit 3/1 is my signature thereon. After the incident, the accused had fled to his maternal uncle's house. Some days thereafter, police arrested the accused and brought him to the police station. I had been to the police station along with Albinus Lakra when the accused was in custody of police. The accused, while in custody of police, confessed that he had assaulted the deceased by means of a bhujali and also disclosed that he had concealed the weapon of offense beneath the grass in an open field near a farmhouse, and he had also concealed a full pant and t-shirt which he was wearing at the time of occurrence in his house. The accused led the police team and the witnesses, including myself, to the place of concealment and gave recovery of the bhujali and the wearing apparels. Police effected seizure of that bhujali and wearing apparels which the accused had worn at the time of occurrence and prepared the seizure list in our presence. I signed on the seizure list as a witness. Albinus also signed on the seizure list. Exhibit 4 and 5 are the seizure list, and Exhibit 4.1 and 5.1 are my signatures thereon. Police had also recorded the statement of the accused leading to discovery of the weapon of offense and wearing apparels of the accused, and had obtained the LTA of the accused thereon. Myself and Albinus had also signed on the statement and as witnesses. Exhibit 6 is that statement and Exhibit 6/1 is my signature thereon. And in the cross-examination, is stating that PW1 had reported the matter in the PS. But PW1 is a police Havildar, my lord. PW3, in fact, PW3 has lost the FIR in the police station. I had arrived at the spot before arrival of PW1. The victim was not in a position to talk clearly. The police where the Bhujali was concealed is an open place and and is accessible to all. We had noticed mark of bloodstain on the Bhujali. It is not a fact that the accused had not made any confession and had not given any statement leading to discovery of the weapon of offense and the wearing apparels of the accused, and that I am deposing falsehood.
So no suggestion even given that there was no dying declaration.
Yes, ma'am.
Then
Yes, next.
PW5.
5, ma'am.
5.
Son.
The son of the deceased.
Minor.
Who, according to PW3, also stated to have seen the appellant running away,
Running away.
Yes.
right?
Yes.
Apart from DT, say, questions are being put. Capable of
The question has been put.
Then next paragraph.
Yes, ma'am.
I
know the accused, who happens to my paternal uncle. The deceased was my mother. The occurrence took place in the year 2003. It was the second day of the month. On that day, I had been to my maternal uncle, my uncle's house, situated in the same village. At about 8 p.m., when I, along with my sister Priyanka, were returning to our house, we heard the shout of our mother and saw the accused running from the side of our house with a bhujali in his hand. We went inside the house and saw our mother lying in the courtyard with bleeding injuries on her person. Being asked, she disclosed that the accused had assaulted her by a bhujali. Thereafter, other villagers arrived at the spot and my mother was shifted to the hospital. I disclosed before the villagers that I had seen the accused running away with a bhujali. The accused used to quarrel with my mother and he used to physically assault her. He was also saying that my mother was showing ego. Police had come to our house for inquiry and had recorded our statement. My mother had died at Raulkala
after 3 days. 3 days after.
2 days after.
2 days after
2 days.
of the occurrence. In the cross-examination, we saw the accused running with a bhujali near our house. By the time I told other villagers, the accused had fled away. It is a fact that I have not stated before the police that the accused used to quarrel with my mother and physically assault her.
Next.
6. Daughter.
She is also my minor daughter.
See,
Is it about 16 years at the time of examination?
same thing, DD.
Yes, ma'am.
Signed it correctly.
Yes.
Yes, ma'am.
Okay, no question practical in defense. So ये गला it is spot वाला गले.
ଆଜ୍ଞା
बाकी ରହିଲା hospital ଦେଖନ୍ତୁ ଆସନ୍ତୁ.
Hospital
ଆଜ୍ଞା
PW
ତାପରେ
11, 12.
ତାପରେ ଡକ୍ଟର କୁ ଆସିବ.
ଆଜ୍ଞା
11, 12.
11 ଟା ହେଲା one Sukanti Ekka, to whom the learned trial court has treated this as a sister of this PW5, but in fact she is a cousin sister of PW5, not that Priyanka. I know the accused who is my co-villager. I also know the deceased Laurencia Ekka, who was the wife of one Sushil Ekka of our village. Accused is the younger brother of the husband of the deceased. Occurrence took place on 2/11/2003 at about 7 p.m. in the evening. At that time, I was returning from the shop. On the way, I met the accused who was running towards west with a bhujali in his hand. I went to the house of the deceased and saw her lying on the veranda of her house with bleeding injuries on her person. I went to inform Emrancia Eka, the elder sister of my mother. The deceased was also another elder sister of my mother. On receipt of information, the above-named elder sister of my mother and other villagers came to the house of the deceased, and the deceased was carried to the hospital where she died. After 2 days after the occurrence, about 2 days after the occurrence, I had been to the hospital to see the deceased, where she divulged before me that the accused has assaulted her by means of a bhujali. At that time, my sister and the daughter of the deceased were also present at the hospital, and they have also heard the deceased saying that the accused had assaulted her. While returning from the shop at the relevant time on the date of occurrence, Sushanta, the son of the deceased, was also with me, and he had also seen the accused running with bhujali in his hand.
Sushant is that PW5.
PW5.
4. Sorry, 5.
5.
5.
In the cross-examination, I had been to the stationery shop of one Sele of our village. Apart from Sushanta, no one else was with me while coming from the shop. I met the accused on the village road near the house of the deceased. Other family members of the deceased, including her parents-in-law, were also present in the house at that time. I did not shout when I saw the accused running with a bhujali. No one else was chasing the accused when he was running. Even after hearing me, no one tried to nab the accused. Then it is not a fact that I have not seen anything, that the deceased has not stated before me that the accused had assaulted her, and that being the near relation, I am
The
deposing.
last witness dying declaration is PW12.
PW12.
12.
Yes.
She is the younger sister of the deceased.
Yes.
I know the deceased, who was my younger sister. She was the wife of one Susileka of Jagarpur. I know the accused, who happens to be the younger brother of the husband of my deceased sister. Hearing about the incident took place in the evening of 2/11/2003. I went to RGH, Rahulkala, to see my injured sister in the early morning of 3/11/2003. There she divulged before me that the accused had assaulted her by means of a bhujali in the evening of 2/11/2003. In the early morning of 4/11/2003, the deceased died at RGH Raulkala. Police had held inquest over the dead body at RGH Raulkala in my presence and prepared inquest report. Exhibit 3 is that inquest report, and Exhibit 3/2 is my signature. Police sent the dead body to Subdivisional Hospital Panpost for PM examination. After the PM, dead body was handed over to us. In the cross-examination, when the deceased divulged before me regarding the incident at RGH Raulkala, her children were also present there.
Yes. Now you come to the doctor who has
Doctor.
recorded.
First,
That is on page 49, madam.
Right.
On 2/11/2003, I was the medical officer, Government Hospital, Rajapur. On that day, on police requisition, that is Exhibit 10/3, in connection with Rajapur PS case number 159/2003, I examined one Laurencia Eka, wife of late Sushil Eka, and found the following injuries.
These are the injuries.
Yes, these are the injuries.
Okay.
Injury number 1 is grievous, and the 2 to 9 are all simple in nature and could have been caused by sharp cutting weapon like bhujali.
Injury number 1, the size 15 cm,
Yes,
so
ma'am.
right temporal region, and right ear, and there was underlying fracture of the skull bone.
skull bone.
Yes.
I had examined the injured at 8:50 p.m. and had referred to RGH Raulkala due to serious nature of injury and the precarious condition of the patient. The injuries found were sufficient to cause death in ordinary course. At the time of examination of the victim, the victim was conscious and was able to talk. Exhibit 10 is the injury report prepared by me, and Exhibit 10/1 is my signature thereon. On that day, soon after the examination, I recorded the dying declaration of the victim in my own handwriting on police requisition, which is Exhibit 11/2, in presence of the staff nurse Rosmi Minj. The examination was in question-answer format. In response to my question, the victim gave out that her brother-in-law, Diora, namely Marianus Ekka, had assaulted her by means of bujali. The victim was mentally fit to give the dying declaration. Exhibit 11 is the dying declaration of the victim recorded by me, and Exhibit 11/1 is my signature thereon.
Hmm.
That is all. The dying declaration was not challenged. Only in his cross-examination, he stated that had the patient been taken to the hospital having a neurosurgeon, she might have survived.
Okay.
Well, at one thing, the FIR has been registered at Raghunathpur PS on 2/11/2003 at 10:30 p.m. But here the PW10, he is stating that on police requisition, he examined the victim and he had examined the injured at 8:50 p.m. That means much prior to the registration of FIR, which is also a doubtful factor, my lord. And
Hmm.
soon after the examination, I recorded the dying declaration of in my own handwriting.
All the witnesses have stated that the including the informant is
Three.
PW3. All of them have stated that from the spot the deceased was taken to the hospital. Nobody has stated that the deceased or anybody went to the lodging of the FIR.
No,
Then
that FIR has been lodged by PW3.
right.
Yes.
So say PW3 ର page number 36 ର paragraph number 3
ଆଜ୍ଞା
ସେ ଯୋଉ spot ରେ କହିଲା dying declaration ପରେ
ହୁଁ
ତାପରେ paragraph 3 ଦେଖନ୍ତୁ, we made arrangement for shifting the Lawrence Eka to the hospital. Okay,
ଆଜ୍ଞା
ସେ କହୁନି ଯେ we made arrangement to take him to the police station.
ନାଇଁ
So hospital କୁ ନିଆଗଲା.
thereafter I prepared the written
thereafter hospital ପରେ କାରଣ ତାଙ୍କର ଯଦି ଆପଣ ଦେଖିବେ ମଧ୍ୟ FIR ର contents ଟା page 25 ରେ
ଆଜ୍ଞା
ଏହି ଆଘାତରେ ଲରେନ୍ସ ର ସୁଆଣ୍ଡସୋରେ ରକ୍ତ ବାହାରୁଥାଏ।
ହୁଁ
ତାର ଏପରି ଅବସ୍ଥା ଦେଖି ଆମେ ତାକୁ ଟେମ୍ପୋ ଠିକ କରି ରାଜଗାଙ୍ଗପୁର ହସ୍ପିଟାଲକୁ ଅତି ଶୀଘ୍ର ଚିକିତ୍ସା ପାଇଁ ପଠାଇଲୁ। ଏହି ଘଟଣାରେ so everybody has stated that from the obviously that was the in order to save the life of that person, he was first taken to the hospital. Then this FIR has been lodged. This statement which has been made by PW10 that on police requisition he examined this man was examined earlier. Police requisition might have come later on because the IO has not been examined. Written report present during course of so and so examined issued injury requisition. Kete number injury
requisition is 10/3.
10 by
3.
no 10/2 is the injury requisition. Is injury requisition টা কার 10/2 এটা 8
ହଁ ସେଟା 10/2 ହବ ବୋଧେ
ହଁ
କାରଣ 10/3 ଏକ୍ସିକ୍ୟୁଟ ଲିଷ୍ଟରେ ଲେଖା ହେଇଯାଇଛି।
ନାଇଁ ନାଇଁ ସେଗୁଡ଼ା ଯୋଉଟା ଦେଖୁ ହଁ ସେଗୁଡ଼ା just wait there. This is exhibit 10 and 10/1 is the signature of the doctor. Time of examination other podichi. That doctor is PW kete je
PW 10.
10. हाँ ये टाइम तो ठीक हुई जो 8:50 आदर पढ़ी टाइम हो एट पढ़ी डेट एंड टाइम ऑफ एग्जामिनेशन 2/11/2003 8:50 है ना से 8:50 बेलू ऑब्वियसली एफआईआर ही नथिला कारण एफआईआर हैला परे एफआईआर हिची 10:30 रे तेणु ऑब्वियसली मेडिकल पुलिस पुलिस रिक्वेशन रे सीन पुलिस रिक्वेशन परे ସେମାନେ ପରେ ପଠାନ୍ତି ତାକୁ because they have been taken to the so hospital first. I have the honor to answer all that on act about so brother-in-law Vujali and night neck and so on the time of injury inflicted on this one so. ସେଇଥିପାଇଁ ଆଧିରେ ଲେଖା ହେଇଛି requisition ଲେଖା ହେଇଛି I have the honor to request you on your examining so and so resident of sent to the hospital on 2/11/2003 ତେଣୁ ସିଏ ଅଲରେଡି ପଳେଇ ଯାଇଥିଲା ଏଇଟା ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ଏଟା ଆଣିବାର ଥିଲା ସେଇଟା ବାଇ ଚାନ୍ସ ବାଇ ମିଷ୍ଟେକ୍ ସେ ଅନ୍ police requisition was received after he has treated police requisition ପାଇଲା ପରେ ହୁଏତ ରିପୋର୍ଟଟା ଫର୍ନିଶ କରିଛି କିନ୍ତୁ ଏକ୍ସାମିନ କରିଛି ତା ପୂର୍ବରୁ କାରଣ ଡେଟ୍ ଅଫ ଏକ୍ସାମିନେସନ ଟାଇମ ମଧ୍ୟ ଆଦେରେ ରିଫ୍ଲେକ୍ଟ ହେଇଛି it is 8:50 so that's not the point
And regarding my lord, that recording of declaration is
just a minute. Hey, you're what's up tonight? You should see you what you are doing. Eleven 2003 at 8:50 p.m. So this is a statement which has been, it's not correct that you are on police requisition he was examined. Police requisition must have come afterwards because time of lodging of the FIR is 10:30. Yes, then what has happened?
then the recording of dying declaration. Also, the PW10 is saying that on police
let us see
requisition.
the dying declaration.
That dying declaration requisition is 11/2 and dying declaration is 11.
That is recorded by PW
10.
10. Garo or say the victim was mentally fit to give dying declaration. Exhibit 11 is the dying declaration. Let us come to Exhibit 11. The 10 tapore requisition lekhala to the medical officer Rairangpur Hospital regarding recording statement of the regarding statement of dying declaration of the injured. Okay. Lawrence Swanso, with reference to noted subject, I beg to state that today, Swanso, the injured, stabbed by her brother-in-law, Swanso, by Swanso, for which she sustained injuries on her belly, Swanso, condition became serious. Therefore, I pray the statement dying declaration may please be recorded. And oblige. Okay. Then the dying declaration comes. ତୁମକୁ କିଏ ମାରିଲା ପ୍ରଶ୍ନ ଯାହା ଫଳରେ ତୁମେ ଏପରି ଗୁରୁତର ଭାବେ କ୍ଷତ ବିକ୍ଷତ ହୋଇଗଲ ଉତ୍ତର ମତେ ମୋର ଦିଅର ମାରିଆନୁସ୍ ଇକା ମାରିକରି ଏପରି ରକ୍ତାକ୍ତ କରିଛି ପ୍ରଶ୍ନ ତୁମକୁ କେଉଁଥିରେ ମାରିଲା ଉତ୍ତର ମତେ ଗୋଟେ ଭୁଜାଲିରେ ମାରିଲା while I recorded the statement patient was seriously injured, but her mental condition was clear. So that certificate has been given and statement has been recorded. So these are
the timing also of the recording of the dying declaration is silent because the timing of recording the dying declaration, although it was recorded on 2/11/2003,
signature ମରାଇଛି ପରା
ହଁ
2 ତାରିଖରେ
2 ତାରିଖ
requisition
ହେଇଛି
ହେଇଛି 2
ସେ
ତାରିଖରେ
ସମୟ
recording ହେଇଛି 2 ତାରିଖରେ ଡକ୍ଟରଙ୍କର ସିଗ୍ନେଚର ଅଛି
କାରଣ ସେ ପିଏସ୍ କେସ୍ ନମ୍ବର ପକେଇକିରି ସମୟ ଦେଇକିରି ରିକ୍ୱେସନ ଯେମିତି ଦେଇଥିଲେ ସେଠି ଏଠି ସେମିତି ଦବା କଥା ଏଠି ସମୟ କିଛି ନାହିଁ
ଏବଂ ଇଏ ମଧ୍ୟ ଆଇଓ ମଧ୍ୟ କହୁଛି ଯେ requisition was made for recording the dying declaration that IO of course was not examined
yes
but during course of investigation KC Bakshi kon ମରିଗଲା ନା
ଆଜ୍ଞା ମରିଗଲେ after submitting the charge sheet
issued injury requisition gala to this one so exhibit one he also prayed to the MO to record the dying declaration of the injured and according to so and so then the doctor goes so first evidence against you presence at the spot right
yes
madam alone in the company of the deceased that has been deposed to by
PW8
PW8 this is the first number 2 you are seen running away from the spot from near the house of the deceased that is seen by PW5 and PW11
PW8 is also seen that running away he ran away on his arrival
ଇଏ କହୁଛନ୍ତି ପୁରା ଘର ପାଖରୁ ଆମେ ଦେଖିଲୁ ଦୌଡ଼ି
ହଁ ସିଏ କହୁଛନ୍ତି ସେ ସ୍ପଟରେ ତାକୁ ଧରିଥିଲା
then 3 ହଉଛି DD before at the spot
Yes.
he is not seen
DD at the spot ହଉଛି 3 4 5 6 8 right
ଆଜ୍ଞା
then 4 is DD at the hospital oral dying declaration at the hospital
And leading to discovery of Bhujali.
go to step by step that is PW11 and 12 right
ଆଜ୍ଞା
number 5
Son of the
written dying declaration
written dying
written DD that is deposed to by PW10 okay
yes
then 6 is the leading to discovery okay, of
Yes,
the weapon of offense, that is
Four.
Bhujali.
Bhujali.
Bhujali and wearing apparel.
Yes.
Yes,
His own wearing apparel.
yes,
Which are found to be blood on C examination.
yes, of human origin, but the blood grouping could not be
Human
ascertained.
blood biome.
Yes, ma'am.
Then 7 is that the Bhujali which was seized, that was sent for
Chemical
the
examination.
opinion of the doctor.
Doctor query
Doctor
report.
opined that the injuries were possible by this Bhujali. Okay. And 8, the homicidal death not disputed.
Yes, but they said Bhujali could not be produced in the court during trial, my lord.
ସେ ଏଠିକି କିନ୍ତୁ ଆସିଥିଲା ଡକ୍ଟର ଯିଏ ଏକ୍ସାମିନ କଲେ
PW7.
PW7
ହଁ ତାଙ୍କ ପାଖକୁ ଆସିଥିଲା
ସିଏ ତାକୁ ତାପରେ
concealed
not only
condition.
that, it was also handed over and it was sent for এটা হচ্ছে
It was handed over to the investigating officer, PW7.
I sealed and labeled the weapon of offense after examination and handed over to the IO. ହେଲା
Yes, ma'am.
ତାପରେ IO କଣ କରିଛନ୍ତି ନା ତାକୁ SDGM ଜରିଆରେ SDGM ନା ହଁ
ହଁ
SDGM
SDGM ଜରିଆରେ
SDGM ଜରିଆରେ ପଠାଇଛି ନାଇଁ JMFC
ସରି JMFC ଆଜ୍ଞା
ତାଙ୍କ ଜରିଆରେ ପଠାଇଛି ଡେପୁଟି ଡାଇରେକ୍ଟର୍ସ କେମିକାଲ ଏକ୍ସାମିନର
RFSL ସମ୍ବଲପୁର
and then ଆସିଲା ଆପଣଙ୍କର ଭୁଜାଲିରେ ଆସିଲା ବ୍ଲଡ ହ୍ୟୁମାନ ଗ୍ରୁପ ଟା नो ओपिनियन
ହଁ yes ma'am
ତାପରେ ଏଇ ଯୋଉ ଡ୍ରେସ ଗୁଡାକ ଯୋଉଟା ମିଳିଥିଲା at the instance of the appellant
yes ma'am
ସେଗୁଡାକ ହଉଛି ଫାଷ୍ଟ ହଉଛି
full pant
ଚେକ୍ ଗାମଛା
ନାଇଁ that check gamcha belongs to the deceased my lord
ଆଚ୍ଛା ତାହେଲେ କଣ ମିଳିଲା
ଭୁଜାଲି ପଇଲା full pant ପାଇଲା
ଭୁଜାଲି ଛାଡି ଦିଅ ଆଉ ଯୋଉ
full
ଡ୍ରେସ
pant ଗୋଟେ ଗଞ୍ଜି ଗୋଟେ
ସେଟା କେତେ ନମ୍ବର
ସେଟା ହଉଛି
full pant right that is the I ହଉଛି
marked as I
ଆଉ ଗୋଟେ ଗଞ୍ଜି ହଉଛି
J
ତ ଏଇଟା ହଉଛି ଆକ୍ୟୁଜ୍ଡ ର
ଆଜ୍ଞା
ଯୋଉଟା କି ତାରି ଇନଷ୍ଟାନ୍ସ ରେ 27 ଏଭିଡେନ୍ସ ଆକ୍ଟ ରେ ଜବତ ହେଲା
ଏଟା ଗଞ୍ଜି ଯୋଉଟା ଫରୱାର୍ଡ କରିଛନ୍ତି while forwarding it has been stated a half ganji but PW4 in his evidence he is saying that a t-shirt has been seized from the house
we'll go to that seizure list ରେ କଣ ଲେଖା ହେଇଛି but now IJ ର ରିପୋର୍ଟ ହଉଛି I ରେ ମଧ୍ୟ ବ୍ଲଡ ମିଳିଲା ଏବଂ ହ୍ୟୁମାନ ବ୍ଲଡ ଆଉ J ରେ ମଧ୍ୟ ବ୍ଲଡ ମିଳିଲା ଗଞ୍ଜି
ତାର ଗ୍ରୁପିଂ ହେଇଛି
ରାଇଟ୍
ଆଜ୍ଞା
ଓପିନିଅନ ଅବଶ୍ୟ ନାଇଁ ଗୋଟେ
G ର ହେଇଛି ଗ୍ରୁପିଂ ଆଜ୍ଞା B ପଜିଟିଭ B ଦିଆଯାଇଛି ଗ୍ରୁପିଂ B
J ଟା ମାନେ ହଉଛି ଗଞ୍ଜିଟା
ଆଜ୍ଞା
ଯୋଉଟା କି ହଉଛି ଆକ୍ୟୁଜ୍ଡ ର
ଗଞ୍ଜି
ଆକ୍ୟୁଜ୍ଡ ଇଏରେ ଗାମଛାର ମଧ୍ୟ ସେଇ ଗ୍ରୁପ ତେଣୁ ଆକ୍ୟୁଜ୍ଡ ର ଇଏଟା ହେଲା
ନାଇଁ ଡିସିଜ୍ଡ ର
ଗାମଛାରେ
ଗାମୁଛା ସାୟା ଶାଢୀରେ ସେଇ ଗ୍ରୁପ
ସବୁ ଗୁଡା ପୁରା ହଁ ସେଗୁଡା ତେଣୁ ତାର ବ୍ଲଡ ଗ୍ରୁପ ହେଲା
B
ହେଲା
ଗଞ୍ଜିରେ
ଗଞ୍ଜିର B ଆଚ୍ଛା ଓକେ ଦେନ୍ ସେଇ ଯୋଉଟା ସେଇଟା ସିଜ୍ ହେଇଛି ଯୋଉଟା କେତେ ନମ୍ବର
ଏକ୍ସିବିଟ୍
ଯୋଉ ତାର ଡ୍ରେସ ଯୋଉ ୱେରିଂ ଆପେରାଲ ସିଜ୍ ହେଲା ସେଟା କେତେ ନମ୍ବର
ସେଟା ହେଲା ୱେରିଂ ଆପେରାଲ୍ସ ଅଫ ଦି ଆକ୍ୟୁଜ୍ଡ ସେଟା ହେଲା ଏକ୍ସିବିଟ୍ 4 and 5 ୱେପନ୍ ଟା ହେଲା 4 5 ଟା ହେଲା ଏକ୍ସିବିଟ୍ ସିଜର ଲିଷ୍ଟ ହେଲା ଏକ୍ସିବିଟ୍ 5
ୱେରିଂ ଆପେରାଲ୍ସ ହେଲା 5 ଟା ବାହାର କଲ ସେଟା ବୁଝିଆଲି ସେଟା 4 ଟା ତା ପରଟା ହଁ ଏଇଟା ମାରିଓର ସେକା ରହୁଥିବା ସୁଆଣ୍ଡସୋରେ ତା ଶୋଇବା ଘରୁ ମିଳିଲା ବଖରାରୁ ଏବଂ ଲେଖା ହେଲା ଉପରୋକ୍ତ କେସରେ ସମ୍ପୃକ୍ତ ଥାଇ ସୁଆଣ୍ଡସୋ ପୋଲିସ ହେଫାଜତରେ ନିଜର ଦୋଷ ସ୍ୱୀକାର କରି ସାକ୍ଷୀ ମାନଙ୍କ ସାମ୍ନାରେ ଘଟଣା ବର୍ଣ୍ଣନା କରି କହି ସୁଆଣ୍ଡସୋ ରେ ପିନ୍ଧିଥିବା ନିମ୍ନଲିଖିତ କପଡା ମାନ ଯାହାକି ସେ ତାଙ୍କର ରେ ରହୁଥିବା ଶ୍ୱଶୁର ଘରର ଶୋଇବା ବଖରାରୁ ବାହାର କରି ସାକ୍ଷୀ ମାନଙ୍କ ସାମ୍ନାରେ ଦାଖଲ ଦେବାରେ ଜବତ କରାଗଲା ସାକ୍ଷୀ ମାନଙ୍କୁ ଜବତର ବିବରଣୀ ବୁଝାଇ ତାଙ୍କ ଠାରୁ ଦସ୍ତଖତ କରାଗଲା। ଓ ଗୋଟେ ହଉଛି ବାଇଗିଣୀ ରଙ୍ଗର ପୁରୁଣା ଫୁଲ ପ୍ୟାଣ୍ଟ, ଜହିଁରେ ରକ୍ତ ଲାଗିଥାଏ କଣ ଗୋଟେ। ଗୋଟିଏ ଲାଲ ରଙ୍ଗର ପୁରୁଣା କି ଗୋଟେ ବ୍ରାଣ୍ଡ ଗଞ୍ଜି ଗୋଟେ ଲେଖା ହେଇଛି, ଜହିଁରେ ରକ୍ତ ଲାଗିଥାଏ ହେଲା। So these are the which were found to be stained with blood. And cause of death, shock and hemorrhage due to extensive blood injuries from bleeding injuries. मेन ब्लोटा दिया है मुंडरे,
ଆଜ୍ଞା
बाकी सब देह सारा
ଦେହ ସାରା। This Bhujali has been seized on 13/11/2003. It was sent to the autopsy doctor on the same day. Thereafter, on 17/2/2004, it was sent to the court to send those to for chemical examination. On 13/11/2003, that Bhujali was recovered. And on 3/2/2004, the IO made a query with regard to the alleged weapon of offense. ତାହେଲେ 13/11 ରିକଭର୍ଡ ହେଲା, 3/2/2004 ପଠେଇଲେ। ଦେରଆଫ୍ଟର ଅନ୍ 17/2/2004 ସେ ପଠେଇଛନ୍ତି କେମିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ।
2004 सीजर
ଆଜ୍ଞା 13/11/2003 ସରିଯିବ।
sorry सीजर ହେଲା, that is exhibit 4, right?
Exhibit 4
then doctor opinion ନିଆ ହେଲା କେବେ?
3/2/2004
3/2/2004
ଆଜ୍ଞା
ତାପରେ ପଠା ହେଲା
17/2/2004
କାରଣ ଏ ଯୋଉ ଚାର୍ଜ ସିଟ୍ ହେଇଛି 28/2 ରେ।
28/2 after sending those exhibit.
And it seems that the report was prepared, C report that was prepared on 22/3 ତାପରେ ତାମାନେ ତା ପରେ ହେଇଛି
ପରେ ଚାର୍ଜ ସିଟ୍ ଦେଲା ପରେ
ପରେ ଆସି କୋର୍ଟ ରେ
ଆଜ୍ଞା
ପହଞ୍ଚିବ।
that to the PW7, he has received that weapon of offense which has been sealed under exhibit 4 in open condition, not in sealed condition. It is his evidence. And after examination, he sealed and handed over to the IO. Thereafter, where it was kept, it is best known to the IAC, who has stated that he is acquainted with the investigation. But later on in his cross-examination, he stated that I am not acquainted with the investigation.
No, but the persons who were seen
Yes, madam.
you
Madam.
leaving the spot, they have also stated that there was weapon in your hand.
Yes,
like
Bhujali.
let us say
PW5 and 11.
Right. So these two witnesses stated PW5 is obviously the minor son.
Minor son.
Okay. Se kouchi je accused was running away from the side of our house with a Bhujali in his hand. Right? Next is PW11.
Yes, madam.
He has also stated
the minor nice something.
Right.
Yes,
that when I on the way I found that he was running in a Bhujali. ତେଣୁ ଭୁଜାଲି ଧରିକିନି ଯିବା ଏବଂ ଘଟଣା ଜାଗାରେ ଯୋଉ ପହଞ୍ଚିଲେ 8 ନମ୍ବର ସାକ୍ଷୀ ଯୋଉ ପ୍ରେଜେନ୍ସ ଟା ଯୋଉ
ଆଜ୍ଞା ସିଏ କହୁନି ଭୁଜାଲି ଧରି, ସେ ଖାଲି କହୁଛି ଯେ ରେନ୍ ଆୱେ।
The accused was holding the deceased. On arrival, left the deceased on away. Deceased was fell down, so and so, neck or so on. With injuries, asked the deceased, he showed that knife.
ଦି ଜଣ କହୁଛନ୍ତି knife, ଆଉ ବାକି ଆଉ the wearing apparels were seized from the house of the accused. PW3 କହୁଛନ୍ତି they were residing in one house.
Those things would have counted much if we would have discarded the other evidence, but what we find about the presence, running away, then DD spot, DD hospital, DD by doctor, mental condition, okay. So these are itself sufficient. Apart from that, it's a homicidal death. and no cross-examination.
No cross.
You see, when the doctor who has recorded the dying declaration is PW10,
10.
so if you'll find his evidence, that is at page PW10 is at page kete number?
49. 49.
49.
49. The doctor has categorically stated that the victim was mentally fit to give the dying declaration. That is at page 50.
Yes, my lord.
And that also he has mentioned in that dying declaration. Hala?
Aye.
No
Not a
suggestion.
single question has been put
No.
that he was not in a ei type ro injury hele,
Aye.
head re injury hele, se মানে balance mind এপট সেপট হবার possibility ଅଛି, ବାଉଳା ଚାଉଳା ହବାର ଅଛି, କିଛି ନାହିଁ, total ନାହିଁ। କ୍ରସ୍ ଏକ୍ସାମିନେସନ ନିଲ୍। ଗୋଟେ କ୍ୱଶ୍ଚିନ୍ ପଚରାଲେ ଯେ ତାକୁ ନ୍ୟୁରୋସର୍ଜନ ପାଖକୁ ନେଇଥିଲେ
ଆଜ୍ଞା
ହୁଏତ ବଞ୍ଚିବାର ତାର
ସେଟା କିଛି
ଚାନ୍ସ ଥାନ୍ତା। ଆଉ ବାକି ଯୋଉମାନେ ବି ଡାଇଂ ଡିକ୍ଲାରେସନ ଓରାଲ ଡାଇଂ ଡିକ୍ଲାରେସନ ହଉ
all are
ଇଏ
consistent.
ହଉଛନ୍ତି କିଛି ଟୋଟାଲ ଜେରା ହିଁ ନାହିଁ।
Only one witness has stated that she was unable to speak clearly.
ହଁ
Only one
clearly।
ହଁ ଜଣେ କହି
ହଁ
ତାପରେ ଲେଟର ଅନ୍ କହିଛନ୍ତି ସେ
ହଁ
that to the medical document of RGS, those are also not seized.
There is PW4 at page 39.
Yes, my lord.
ହୁଁ।
PW last para.
Last
People
paragraph.
one had reported the matter to so and so. I had arrived at so and so. The victim was not in a position to talk clearly.
ହୁଁ।
The only witness who has stated.
Yes, my lord.
କାରଣ ଆପଣଙ୍କର ଯେତିକ ରହିଛି ବାକି ତକ ଇଞ୍ଜୁରି ସିମ୍ପଲ ରହିଲା, କିନ୍ତୁ ଯୋଉ ଫାଟାଲ ଇଞ୍ଜୁରିଟା ରହିଛି ଯୋଉଟା
Injury
ପାଇଁ
number
ଡେଥ୍
1.
ହେଇଛି that was on the head। ଆଉ ଏଇ ଯୋଉ ଇଞ୍ଜୁରି ଗୁଡାକ ଆପଣ ଦେଖନ୍ତୁ ସବୁ ଗୁଡାକ ଇଞ୍ଜୁରି ବେଳେ ଲେଖା ହେଇଛି ଷ୍ଟିଚ୍ ଡୁଣ୍ଡ।
ଆଜ୍ଞା ସବୁ ଷ୍ଟିଚ୍।
ଟ୍ରିଟମେଣ୍ଟ ଯୋଉ 2 ଦିନ ହେଇଛି
ଆଜ୍ଞା।
ଡକ୍ଟର ଷ୍ଟିଚ୍ କରିଛନ୍ତି।
ତେଣୁ ସେ
ପୋଷ୍ଟମର୍ଟମ
ଟ୍ରିଟମେଣ୍ଟ ଷ୍ଟିଚଟା ସେଠୁ ରାଜାପୁର ହସ୍ପିଟାଲ ହେଇଛି କି କେମିତି ରେଫର ହେଲା ସେଟା କିଛି ନାହିଁ।
ଏଠି ତ ମଲା ପରେ ଆସିଛି ନା, ଏଠି ପିଏମ ହବାକୁ ଏଠିକି ଆସିଛି।
ଆଜ୍ଞା ପାନପୋଷ୍ଟ
ଯୋଉଠି
କୁ ଅଛି।
ବର୍ତ୍ତମାନ ଇଏ ଯୋଉ ଆସିଲା ସବ ଡିଭିଜନାଲ ହସ୍ପିଟାଲ ପାନପୋଷ୍ଟ କୁ ଯାଇଛି ପୋଷ୍ଟମର୍ଟମ,
ପୋଷ୍ଟପୋନ୍ ହବା ପାଇଁ
ବଟ୍ ଟ୍ରିଟମେଣ୍ଟ ସେଠି ହେଇଛି। ମାନେ
ସେ ଟ୍ରିଟମେଣ୍ଟ ପାଇଁ ବି କିଛି
ଟ୍ରିଟମେଣ୍ଟ
ଡକୁମେଣ୍ଟ ନାହିଁ ମେଡିକାଲ ଡକୁମେଣ୍ଟ।
ଟ୍ରିଟମେଣ୍ଟରେ ଯୋଉ ଡକ୍ଟର ଡାଇଂ ଏଇ ଯୋଉ ତାକୁ ଏକ୍ସାମିନ କରି ଯୋଉ ଦେଇଛି
ସେଟା ହଉଛି
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ହସ୍ପିଟାଲ
ଫାଷ୍ଟ
ରାଜଗାଙ୍ଗପୁର।
ଏଡ୍ ଟ୍ରିଟମେଣ୍ଟ ଯୋଉ ଦେଇଥିଲେ ସିଏ
ଦେନ୍ ସିଏ କହୁଛି
ସେ ରେଫରେନ୍ସ କଥା କହୁଛନ୍ତି ଏଠୁ ଆରଜିଏସ୍ ରାଉରକେଲା, କିନ୍ତୁ ଆରଜିଏସ୍ ରାଉରକେଲାର କୌଣସି ଡକୁମେଣ୍ଟ ନାହିଁ। ବଟ୍ ଦି ଓରାଲ ଏଭିଡେନ୍ସ ଅଫ ଦ PW11 and 12 that the inquest was held at RGH।
ଡେଥ୍ ଆରଜିଏଚ୍ ରହିଛି କାରଣ
ଆଜ୍ଞା
ଇନକ୍ୱେଷ୍ଟ ସେଇଠି ହେଇଛି।
ଇନକ୍ୱେଷ୍ଟ ସେଠି ହେଇଛି।
ଇଏ ତାକୁ ଇଏ କରିକିନି ଟ୍ରିଟମେଣ୍ଟ କରିକିନି ଯାହା ପ୍ରାଇମେରୀ ଜିନିଷ କରିକିନି ତାକୁ ପଠେଇଦେଲା, କାରଣ ତା କଣ୍ଡିସନ କ୍ରିଟିକାଲ ହେଇଗଲା। ସେଇଠି ଯେ
ନା ସେଠି ଟାଇମିଂ ବି ଆଜ୍ଞା ବହୁତ ସମୟ ରହିଛି ସେ ରାଜାପୁରରେ।
found or found insufficient at the time of exam, the victim was conscious, able to speak। So
ପ୍ରାୟ 3 ଘଣ୍ଟା ଖଣ୍ଡେ ରହିଛି ସେ ରାଜାପୁର ହସ୍ପିଟାଲ।
ଏଇ ଯୋଉ ଡାଇଂ ଡିକ୍ଲାରେସନ ର ଯୋଉ ଡକ୍ଟର କନସିୟସ୍, ଏବୁଲ ଟୁ ସ୍ପିକ୍, mental fit state of mind, ଏଗୁଡାକର total unchallenged, and even if there would have not have been any evidence, but this evidence of the doctor who has stated that would have been also sufficient apart from
ଆଜ୍ଞା
yes Mr.
Yes, sir.
What do you say? Hey, Dr. What is the motive behind the commission of the crime?
motive was not proved, my lord।
ନାଇଁ ଗୋଟେ କି
ସେ
କହୁଛି
PW5 କହୁଛି, PW5 କହୁଛି ଇନଫର୍ମାଲ ବି କହୁଛି। 5 କହୁଛି ଯେ ମୋ ମାଙ୍କୁ ସେ ଝଗଡା କରୁଥିଲେ ମାରୁଥିଲେ। ଇନ୍ କ୍ରସ୍ ଏକ୍ସାମିନେସନ when it was confronted that ସେ କହିଲା ଯେ ନାଇଁ ମୁଁ I have not stated before the IO। ଆଉ PW3 କହୁଛି although they were residing in one house but in separate mess, ତାର ସମ୍ପର୍କ ବି ଭଲ ନଥିଲା।
PW3
ଆଜ୍ଞା PW3 para 2 Though the deceased and accused were living in one house, but they were separate in mess. They were not pulling on well. ସେଟାକୁ ତ ଏଇ ଷ୍ଟେଟମେଣ୍ଟଟା ଆଉ କେହି corroborate କରିନାହାନ୍ତି.
For what reason it has not been
No,
disclosed?
my lord. And regarding the presence
କାରଣ
of
ଯେତେବେଳେ ଘଟଣାଟି ହେଇଛି ଘରେ ଆଉ କେହି ନଥିଲେ।
ହଁ ସେ PW11 କହୁଛି ଯେ mother in law and children were there. PW11 ସେ ତାଙ୍କ ଷ୍ଟେଟମେଣ୍ଟରେ କହୁଛନ୍ତି other family member, page 52, my lord. Other family members of the deceased, including her parents and in-law, were also present in the house at that time, at the time of occurrence.
ଏକ୍ସାମିନ ହେଇଥିଲେ ବି ତ ପୁଅକୁ ସପୋର୍ଟ
ହଁ ପୁଅ ମୋଟିଭଟା ପ୍ରୁଫ୍ ହେଇନି।
କେତେ ବର୍ଷ ରହିଲାଣି ଇଏ?
ଇଏ ବୋଧେ ବେଲରେ ଆଜ୍ଞା ଯାଇଛି।
on bail.
ଆଜ୍ଞା 2014 ବେଲ ହେଇଛି।
ପିରିୟଡ ପାଇଁ ଡିଟେନସନ ପିରିୟଡ 10 ବର୍ଷ ପାଇଁ ଜେଲ ଦେଖି ଆଇଛି। 10 ବର୍ଷ 8 ମାସ ପରେ ଜେଲ। Anything any of to take down JCRLA number 126 of 2005. The appellant Mariano Sica faced trial in the court of Second Ad hoc Additional Session Judge Sundargarh in Sessions Trial number 23/112 of 2004-05 for offense punishable under Section 302 of the Indian Penal Code on the accusation that on 2/11/2003 at about 8 p.m. at village Jhagarpur, he committed murder of Laurencia Ika, bracketry hereafter the deceased, who was his sister-in-law, by means of a bhujali. The London Trial Court, by judgment and order dated 29/6/2005, found the appellant guilty of the offense charged and sentenced him to undergo imprisonment for life and to pay fine of rupees 10,000 in default to undergo rigorous imprisonment for a further period of 1 year. As per the first information report lodged by PW3 Augustus Ika, on 2/11/2003 before the inspector in charge of Rajgangpur police station, in short is that on that day in the evening hours, the villagers were celebrating a festival in the graveyard. and some puja was being performed there. At about 8 p.m., PW3 heard hulla from the side of the house of late Susilika. And accordingly, as the headman of the village, he came to the house of late Susilika along with others, and found that the deceased was the widow of late Susil Ika, was lying in a seriously injured condition with bleeding injuries on different parts of her body, and she was shouting to save her. When PW3 asked the deceased as to how she sustained injuries, the latter told that the appellant assaulted her by a bujali on account of family dispute. And when the villagers reached, the appellant fled away from the spot. There was injuries on the abdomen, hand, neck, and other parts of the body of the deceased. And there was also profuse bleeding from the injured parts. Immediate arrangement was made to shift the deceased in a tempo to Rajgangpur Hospital for treatment. Stop. On the basis of such report, bracketary exhibit 2, presented by PW3, the inspector in charge registered Rajgangpur PS case number 159, dated 2/1/2003, under section 341, 326, 307 of the Indian Penal Code. And directed Sri K.C. Bagh, SI of Police, Rajgangpur Police Station, to investigate the case. During course of investigation, the IO examined witnesses, issued injury requisition in favor of the deceased, who was undergoing treatment at Government Hospital, Rajgangpur, and also prayed to the medical officer to record the dying declaration. The IO visited the spot, prepared the spot map, Exhibit 12. He also seized the bloodstain earth and sample earths from the spot as per seizure list Exhibit 9. On 4/11/2003, the IO received information regarding the death of the deceased while undergoing treatment at RGH Raurkela, and accordingly proceeded to RGH Raurkela, held inquest over the dead body and prepared inquest report Exhibit 3 and sent the dead body for post-mortem examination to Subdivisional Hospital Panpos, and intimated the court that the case has turned to one under Section 302 of the Indian Penal Code. On 5/11/2003, the IO seized the wearing apparels of the deceased along with her personal belongings on production by the escorting constable after post-mortem examination as per seizure list Exhibit 1. On 6/11/2003, the appellant surrendered in court and a prayer was made by the investigating officer to take the appellant on remand, which was allowed, and the appellant disclosed before the IO to have committed the crime and also disclosed to have concealed the weapon of offense bracketed Bhujali at a particular place, and accordingly his statement under Section 27 of the Evidence Act was recorded, and he led the police as well as the witnesses and gave recovery of the weapon of offense which was seized as per seizure list Exhibit 4. The wearing apparels of the appellant, which were stained with blood, were also seized as per seizure list Exhibit 5. The IO prayed before the medical officer for collection of the sample blood and nail clippings of the appellant, and accordingly the same was done, and it was produced before him, which were seized as per seizure list Exhibit 13. The IO made a prayer before the Tahsildar Rajgangpur for demarcation of the spot and received the trace map by the Exhibit 14/1 prepared by the Tahsildar. The I also received the injury report, PM report, and dying declaration from the medical officer. On 3/2/2004, the IO made a query with regard to the weapon of offense from the medical officer and received the opinion. The seized articles, which were kept in Malkhana of the police station, were sent to RFSL Sambalpur for chemical examination through the Lanen JMFC Rajgangpur. And subsequently, the C report was received. On completion of investigation, the IO submitted charge sheet against the appellant on 28/2/2004 under section 302 of the Indian Penal Code. As it appears, the investigating officer could not be examined during trial as he expired, and therefore PW13 Robinaran Barik, the inspector in charge of Rajgangpur police station, who was acquainted with the handwriting and signature of the investigating officer, proved the case records, and the investigation which was carried out by the IO in this case, and also proved the documents prepared by the IO. Next para, after submission of charge sheet, the case was committed to the Court of Session, where the Learning Trial Court, after complying due committal procedure, where the Learning Trial Court framed charge against the appellant as aforesaid, and since the appellant pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 13 witnesses for them. The prosecution also proved marked 16 documents as exhibits. One nose ring was marked as MO1 from the side of the prosecution. The defense plea of the appellant was one of denial, and it was pleaded that at the time of occurrence, the appellant was not present in his house and he was driving a truck. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to hold that the version of PW4 is clear, cogent, and trustworthy, and corroborates the version of PW3 in material particulars. And the disclosure made by the deceased implicating the appellant as the perpetrator of the crime. The version of the minor son of the deceased was examined as PW5, was also accepted. So also the evidence of the witnesses to the dying declaration made at the spot as well as in the hospital. The London trial court also accepted the dying declaration recorded by PW10 on the prayer of the investigating officer at Government Hospital, Rajgangpur. And it was held that from the ocular testimony as well as medical evidence, the only irresistible conclusion can be arrived is that the appellant is the perpetrator of the crime and he had assaulted the deceased by means of bhujali, and the injuries caused by such assault gave rise to the death of the deceased. The London trial court didn't give much importance to the non-production of the material objects, including the weapon of offense. To be a ground to disbelieve the prosecution case. The London trial court further held that there is nothing on record to suggest that the appellant assaulted the deceased due to sudden provocation given by the deceased, and the occurrence took place in the heat of passion following sudden quarrel. And therefore, it doesn't come within any of the exceptions provided under Section 300 of the Indian Penal Code to bring the act of culpable homicide not amounting to murder. Accordingly, the London trial court found the appellant guilty under Section 302 of the Indian Penal Code. The Mr. Akhil Kumar Beura, the London amicus curiae, contended that the doctor, bracketary PW10, who has treated the deceased on 2/11/2003 at Government Hospital, Rajgangpur, and also recorded the dying declaration, has stated that on police requisition, he has examined the deceased and he stated the time of examination to be 8:50 p.m. on 2/11/2003. It is argued that the past information report was registered on 2/11/2003 at 10:30 p.m. and therefore, if any requisition has been made that must have been after 10:30 p.m. And the very statement made by the doctor that on police requisition he examined the deceased at 8:50 p.m. indicates that some earlier report was lodged prior to 10:30 p.m. on the basis of which police requisition was prepared, and on the basis of that the doctor has given his opinion, but that report has not seen the light of day, which makes the prosecution case suspicious. The Land Council further submits that though oral dying declaration has been made at the spot, which is deposed to by 5 witnesses, that is PW 3, 4, 5, 6, and 8, and at the hospital by 2 witnesses, that is PW 11 and 12. So also the doctor, bracketed PW 10, who has recorded the dying declaration, but it cannot be lost sight of the fact that the deceased had sustained a very serious injury on the right temporal region, and there was underlying fracture of the skull bone. And the condition of the deceased was very critical after receiving the injuries. And in such a condition, the mental fitness of the deceased is a doubtful feature. And since the prosecution has, since one of the witness to the dying declaration, that is PW କିଏ କହିଲା ସେ ଯୋଉଟା ତାର ଭଲ କିନି କ୍ଲିୟରଲି କହିପାରୁନଥିଲା
PW 4.
4, and since PW 4 come I witness to the dying declaration stated that the deceased was not in a position to talk clearly, it would not be proper to accept the dying declaration. The London Council further argued that though after the appellant was taken on remand, a bhujali and his wearing apparels were stated to have been seized, but the weapon was seized on 13/11/2003 as per seizure list exhibit 4, and it was sent for doctor's opinion on 3/2/2004, and the doctor bracket PW10 has stated that PW10 the doctor?
ଆଜ୍ଞା PW10 ହଉଛି ଫାଷ୍ଟ ଡକ୍ଟର ଯିଏ ଟ୍ରିଟ୍ କଲା, PW7 ହଉଛି ଅଟୋପସି ଡକ୍ଟର।
नहीं ऑटोप्सी डॉक्टर ऐसे जो कंडीशन ने जो ओपन रिसीव कला सेटा किए डॉक्टर
ନା ସେଟା PW7
अच्छा and the doctor bracket PW7 who conducted the postmortem examination has stated that open condition ने पहला बोली कोड लिखी
ଆଜ୍ଞା କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଅଛି।
हाँ
I received the weapon of offense without any seal.
when he received the weapon of offense it was without seal, and after examining the same he sealed and labeled the weapon of offense and handed over the same to investigating officer. He further submitted that the weapon was sent for CE examination through court on 17/2/2004. And since there is lack of evidence on record that the weapon after its seizure was kept in safe custody and there was no chance of tampering with the same, the seizures also the finding of the human blood as per the CE report becomes inconsequential. It is further argued that the prosecution has not established any motive on the part of the appellant to commit the crime. And therefore, it's a fit case where benefit of doubt should be extended in favor of the appellant. The Land Council submits that the witnesses who arrived at the scene of occurrence after hearing Halla gave contradictory version regarding the place where the injured was found. All right. Mr. Tripathi led an additional standing counsel for the state of Odisha, on the other hand, supported the impugned judgment and argued that PW8 has stated about the presence of the appellant in the company of the deceased at the spot while the deceased was in an injured condition. PW5 and PW11 had seen the appellant escaping, holding the weapon of offense. Though PWs 3, 4, 5, 6, and 8 have stated about the dying declaration made by the deceased at the spot, nothing has been elicited in the cross examination to disbelieve their evidence. Similarly, the evidence of PW 11 and 12, who have stated about the dying declaration at the hospital, have also remained unchallenged. He further argued that the Dr. PW10, who treated the deceased at Government Hospital, Rajgangpur, specifically stated that he received that he recorded the dying declaration of the deceased and proved the dying declaration exhibit 11, and further stated that at the time of his examination, the deceased was conscious and was able to talk, and that the deceased was mentally fit to give the dying declaration, and the said aspect has also been mentioned in the dying declaration sheet. And the doctor's evidence has remained unchallenged. The Land Council further argued that all the witnesses have stated that from the place of occurrence, the deceased was shifted to the hospital as his condition was critical to save her life. And after the deceased was admitted in the hospital, the report was presented before the inspector in charge of Rajgangpur police station on at 10:30 p.m. on 2/11/2003. And the statement of the doctor bracketary PW10 that on police requisition he examined the deceased is a inadvertently made, which was not correct in view of the oral as well as documentary evidence on record. The doctor has specifically mentioned in the injury report about the time of examination to be 2/11/2003 at 8:50 p.m. And therefore, it cannot be said that there was an earlier report before the officer inspector in charge, which has been suppressed. And even the inspector in charge has not been given any suggestion regarding suppression of the first information report. The Land Council further argued that the recovery of the Bhujali has been stated, has been proved not only by the IIC basing on the document prepared by the IO, but also the independent witness like PW4. And IIC specifically stated that the seized articles were kept in safe custody in PS Malkhana. And this aspect has not at all been challenged in the cross-examination. And therefore, merely because it was produced late before the doctor and sent to the chemical examiner, the same cannot be a ground to disbelieve the seizure of the weapon and that there was tampering with the seized weapon, particularly when the doctor after examining the weapon of offense, has specifically stated that the injuries sustained by the deceased were possible by such weapon. The Lennon Council further argued that even though the weapon of offense has not been produced during trial, but in view of the available materials on record, it can be said that rightly the Lennon trial court has held the appellant to be the author of the crime, and therefore the JCRLA, being devoid of merits, should be dismissed. Adverting to the contention raised by the Lennon Council for the respective parties, and before going to deal with the other evidence on record like dying declaration, both oral and written, leading to discovery, etc., we want to first deal as to how far the Lennon trial court, how far the prosecution has established that the deceased met with a homicidal death. PW 7 conducted post-mortem examination at Subdivisional Hospital Panpost on 4/11/2003 over the dead body of the deceased, and he noticed the following external injuries. Quote kar dewe tar. He also noticed the following internal injury and opined the cause of death to be shock and hemorrhage due to extensive injuries, and that the injuries were sufficient to cause death in ordinary course of nature. Nothing has been elicited in the cross-examination, and the Lennon amicus curiae has also not challenged the finding of the Lennon trial court that the deceased met with a homicidal death. In view of the inquest report, the post-mortem report finding the evidence of the Dr. bracketary PW7, we are of the view that the prosecution has successfully established that the deceased met with homicidal death. The evidence of PW subparagraph. The evidence of PW 8 indicates that when he heard sound from the house of the appellant and the deceased while he was performing customary worship in the graveyard, he came to the house of the he came to their house and found in the courtyard the appellant was holding the deceased, and on his arrival the appellant left the deceased and ran away, and he noticed the deceased was having bleeding injuries on her neck, belly, arms, legs, etc. Made by the appellant on the deceased, but the presence of the appellant in the company of the deceased in the courtyard of their house while the deceased was in a critical condition after receiving number of injuries on her person is one of the important circumstance against the appellant. PW5 and PW11 both have stated that they had seen the appellant running away from his outside, from the side of his house, holding Bhujali. And nothing has been elicited in the cross-examination to disbelieve such aspect. Only PW11 has stated in the cross-examination that he did not shout when he saw the appellant running with the Bhujali, and nobody tried to nab the appellant. Therefore, this is another clinching circumstance against the appellant, that he was seen running away from the spot holding Bhujali. PWs 3, 4, 5, 6, and 8 reached at the scene of occurrence, and immediately after the occurrence, and all of them have stated that at the spot the deceased made dying declaration that the appellant assaulted her by Bhujali. And nothing has been elicited in the cross-examination to disbelieve this aspect. Therefore, the oral dying declaration before these 5 witnesses has also remained unchallenged. PW11 and PW12 have stated that while the deceased was hospitalized, they had gone to meet him, and the deceased divulged before them that the appellant had assaulted her by means of Bhujali. Nothing has been elicited in the cross-examination of these 2 witnesses. The doctor, bracketed PW10, who initially treated the deceased, and prepared the injury report exhibit 10, stated that he recorded the dying declaration of the deceased in his own handwriting on police requisition in presence of staff nurse Rashmi Means, and the examination was in a question answer format. And in response to his question, the deceased gave out that the appellant had assaulted her by means of bhujali. The doctor has not only stated that the deceased was conscious and was able to talk, but further stated that the deceased was mentally fit to give the dying declaration. The dying declaration has been marked as Exhibit 11. Only one question has been put to the doctor, and he has stated had the deceased been taken to the hospital having a neurosurgeon, she might have survived. Therefore, there was no challenge from the side of the defense relating to the mental health condition of the deceased at the time of making the declaration. Therefore, we find that the Lennon trial court has rightly placed reliance on the dying declaration which has been deposed to by PW 3, 4, 5, 6, 8 at the spot, 11 and 12 at the hospital, and the doctor bracketed PW 10 who recorded the same. Law is well settled that there can be conviction on the basis of dying declaration if the court is satisfied that it is truthful and genuine. And it is not at all necessary to seek for corroboration. And the court should not discard the dying declaration on flimsy and fanciful reasons. The court has to see whether the declarant was in a fit state of mind while making the statement, and whether there was any possibility of tutoring the deceased to make any false statement against somebody on account of suspicion or any hostility. Consistency in the dying declaration is another aspect which the court should give proper weight. Nothing has been brought on record that the deceased had any grudge against the appellant to implicate him falsely in her dying declaration. In view of the materials available on record, when not only the doctor's evidence makes it clear that the deceased was in a fit state of mind, and she was able to talk, but the dying declaration given at the three stages, that is at the spot, in the hospital, before the independent witnesses, so also before the doctor, is consistent. And in all the dying declaration, the appellant has been implicated to be the author of the crime. We are of the humble view that the London trial court has rightly placed reliance on the same. Not only in the dying declaration it is mentioned that the weapon of offense was Bhujali, but also after the seizure of Bhujali, it was sent to the doctor who, on examining, Dr. Lekhidiyantu, PW7, who on examining the weapon has opined that injuries found on the person of the deceased were possible by said Bhujali. And the query report has been marked as Exhibit 8. The evidence of the investigating officer, IIC, PW13, that the seized articles were kept in safe custody in Malkhana of the police station has not at all been challenged in the cross-examination. The Bhujali was sent for chemical examination, and the doctor noticed that human blood was found on it. The wearing apparels of the appellant, which were seized at his instance, that is full pant and ganji, were also found to have contained human blood. And the ganji was containing human blood of group B, which was the blood group of the deceased, as found from the C report in her sari, saya, and one gamcha. The submission of the Land Council that the prosecution has failed to prove the motive behind the commission of the crime. We are of the view that when the evidence has common record that the deceased and the appellant, though were living in one house, but they were staying in separate mess and they were not pulling on well. And even though in the accused statement, the appellant has stated that there was good relationship between him and the deceased, but when the evidence of the prosecution regarding the other aspect which have already been highlighted above, that is the presence of the appellant at the spot with the deceased, the dying declaration made at three places before at the three stages are acceptable. Moreover, the doctor's opinion that the seized weapon at the instance of the appellant can cause the injury which was found on the deceased. Non-proving of motive cannot be a ground to disbelieve the prosecution case. In view of the foregoing discussions, we are of the view that the finding of the London trial court that the prosecution has successfully established the charge under section 302 of the Indian Penal Code against the appellant is quite justified, and we find no infirmity in the impugned judgment. Accordingly, the conviction and the sentence passed thereunder is upheld, and the JCRLA being devoid of merit stands dismissed. It appears that the appellant was taken into judicial custody on final count on kete on on 6/11/2003, and he was never released on bail during trial. And after he preferred this JCRLA, this court granted him bail on 17/7/2014. The appellant shall surrender before the London trial court within 2 weeks from today, failing which the London trial court shall take appropriate steps for his arrest to serve the and his detention, so that to serve the this sentence imposed by the London trial court, which has been confirmed by us today. Put a note of appreciation on Mr. Beura's and also Mr. Tripathi, and 7,500 is to be paid to Mr. Beura by the registry.
Copy will be served to the
Huh?
yes. Yes.
କଣ ହେଲା?
copy
Okay.
of this order
Uh-huh.
may be remitted to the lower court.
Obviously that order.
I beg your pardon, my lord, my spelling of my name may kindly be corrected.
Criminal revision under juvenile justice.
Pardon to make a mention, my lords. CRLA 236 of 2019, my lords. The appellant herein was convicted and has been sentenced to RI for 12 years. In the meantime, he has almost spent half of the sentence.
Let's tied up bail matters of him.
Pardon to mention, your lordship. IA number 256 of 24, your lordship. In criminal appeal number 685 of 21, your lordship. The petitioner's father has died, your lordship. And the rituals are starting from 5th February, your lordship. It may be listed tomorrow.
Have you served a copy on the State Council?
Yes, lordship.
You take
sir.
instruction from the IAS, give an extra copy so that he can get it listed.
Pardon to mention, my lord. My lord, may I mention BAPL number 10781 of 2023? My lord, I'm seeking permission to withdraw this bail application as per the instruction of the client, my lord.
Okay, it will be listed tomorrow and then you can withdraw. Please tell the number once again.
10781 of 2023, my lord.
Okay, noted down. It will come tomorrow.
Obliged, my lord.
Supplementary list item number 1.
May I please, your lords? My lord, I'm on VC, my lords.
Yes.
My lord, last occasion on 1st December, my lords has directed to take instruction whether 82, 83 process have been issued or not. Because it's a case of the year 2017. This petition is a military personnel, my lords.
Lordship, we have received the instruction. No summons, no process under section 82 and 83 has been issued, your lordship.
Yes, now you have received the case record.
My lord's case diary is there in a connected matter. We're trying to find it out. If it's not available, I'll get it again from the
Pick
police.
up next week. Okay.
Lordship.
The London Council for the State submitted on instruction that no processes under sections 82 and 83 CRPC have been issued against the petitioner. However, he submits that the matter may be adjourned to next week in order to get the case diary. Put up this matter next week. Yes.
1 week after your lordship may say.
Okay. 1 week after kar diyon, hala? Put up this matter commencing from 12th of February 2024. Yes.
Item number 2.
Sorry to make a mention. Sorry to make a mention. The authority will ask this matter of the fellowship because the file was not available.
Yeah.
Because the file was not available, with the state matter couldn't take it out. I pray for 2 more matters.
Which matter?
It's a BLAPL 1221.
It is not in the list.
Not in the list, minutes.
Okay. Give it.
For 2 years,
Okay.
for 2 more.
Yes.
Obligation.
Yes.
Number 2 matters are there in one matter I am appearing and in other matter my lord and senior is appearing my lord. They are facing trial my lord and I am giving all the deposition copies to my lord and friend. Here the petitioners are my lord in custody since my lord 2nd of January 2021 my lord. And my lord, I have 59 of charge sheet witnesses my lord. 31 numbers of charge sheet witnesses have been examined and now my lord, the examination of the IO is
Okay.
going on.
Some deposition copies were wanting. That is why you are asked to furnish it. Have you furnished
I
it?
have.
So, what evidence has come on record against the petitioner? I mean, both in each of these BLAPL, one petition is there.
Yes.
Okay. Have you checked it?
Lordship, both the petitioners have been implicated by oral dying declaration of 2 different set of witnesses, my lords.
Who are they?
Lords, PW 7, 8 and 9.
PW 7, 8 and 9.
Who got the oral dying declaration from the spot itself.
Oral dying declaration at the spot.
Yeah.
Okay.
And 10 and 11, your lordship, who got the oral dying declaration while the deceased was being transferred in the ambulance.
Ambulance. Okay. So, no eyewitnesses are there.
No, this is
No,
a
no.
case where there is no eyewitness evidence.
No eyewitness.
And the funny thing
Since-
about it is,
Since when this petitioner are in judicial custody?
2nd
I
of January.
think, no, the custody is from 5th of January,
5th of January means?
2021. The incident happened on 2/1/2021. Lords, I have filed a convenience note, your lordship. And
Where is that?
on 2/1/2021, my lords, the incident has happened.
Have you supplied a copy?
Yeah, I have given a
Yes,
copy.
yes.
Your lordship may note the first date, 7:15 p.m., my lords. 2 people were found lying injured near the house of one Suresh Sadang. This led to an FIR being registered on the next day, 3/1/2021. And sections 120B, 147, 148, 302, 506, read with 149, and 25 and 27 Arms Act. Now there, the informant who is now dead, he alleged that his father and the other person, they were assaulted and injured because of political enmity. And that his father had disclosed to him the names of their assailants, including the petitioner.
Okay.
Now, on that very same day, my lords, inquest had been held, my lords. And this deceased informant and some of the other witnesses to the dying declaration, they are also witnesses to the inquest. In column 9 of the inquest report, there is no mention about the dying declaration, nor also names of any assailants are there. On the same day, my lords, the deceased informant and PW10, they are the sons of the two deceased respectively, and they have been examined on section 161. On 5th of January, my lords, arrests were effected.
5th of January
2021.
So your client was arrested on 5th.
My lords.
What about your client?
22nd, my lord.
22nd of
January 2021.
21. Okay. Yes.
On 1/5/2021, my lords, charge sheet was filed.
Okay.
341, 302, 120B, 109, and 34 IPC, 25 and 27 Arms Act. Now, my lords, it has been committed, and the trial is at the fag end, my lords. The examination in chief of the IO is going on. The next date relates to a rejection of the bail application of the petitioner. On 15/9/2021, my lords rejected the bail application on the ground that my name finds place in the dying declarations. Then, my lord, serially I have given the dates when the witnesses to the dying declaration were examined. On 25/11/2022, my lords, PW6 was examined. He was the pharmacist on duty in the ambulance, my lords. The prosecution story, my lords, is that one of the deceased, that is Kulamani, he made a statement before the ambulance came to the spot.
Both the deceased were taken in one ambulance?
Yes.
Okay.
So far as Pagola alias Kulamani is concerned, his dying declaration is made at the spot, my lords. The other person, my lords, Divya Singh, he is said to have made the dying declaration inside the ambulance after the vehicle reached Mahanga CHC, and from there he was referred to Cuttack, my lords.
Both were referred to Cuttack?
No, one was referred to Cuttack. One was found dead at Mahanga.
Oh, I see. Okay. Who died at that? Pagal died?
Pagal died. Pagal alias Kulamani. Divya Singh was referred to SCB, and on the way, he allegedly asked for water. PW10 gave him water and queried him, and he has made a dying declaration. Now, this pharmacist, my lords, who was there in the vehicle, he does not state anything about this dying declaration. His specific evidence, my lords, is in cross-examination, in chief, is that both of them were in serious condition.
Just a minute, let me see them. PW6?
Yes. PW6 has stated that both were in serious condition.
Which paragraph you are placing?
Yes. Paragraph, my lords.
Who it is condition serious? Paragraph 2 re question condition serious.
Condition of both injured were serious. At that time, Divya Singh was able to move his lips, but Kulamani was unable to talk, being motionless. Cross-examination, your lordship may see the last line. He says, it is a fact that I had stated before the police that while proceeding to Cuttack in the ambulance, relations of injured Divya Singh present with us were asking him something, but he was not talking anything. This is the evidence of the pharmacist. Now, the next witness is PW7. He was examined on 23/12/2020. His evidence, my lords, may look at paragraph 2 of PW7. 4 lines from the bottom. I also found both
PW7.
Again. I also found both Pagola Barala and Divya Singh Barala. Para 2, 4 lines from the bottom.
1, 2, 3.
I also found the sentence speaks.
Paragraph 2 sorry next page.
7th.
No, first page or last
page? Oh, first page. Said Pagola told.
I also found both Pagola and Divya Singh were bleeding
bleeding condition.
With bleeding condition, were lying on the road. Blood was oozing out from their heads. Ramakanta was holding Kulamani and asked him as to how such incident occurred. Said Pagoda Baral told that Panchanana Sethi, Chaitanya Sethi, Kailasa Khatua, Umesh Khatua, Santosh Pani, Pramod Biswal, Prafulla Biswal, Vijay Baral, Lalit Baral, that is the petitioner. Malay Badik is my learned friend's petitioner. Bhikari Swai, Umakanta and Khitis have assaulted him by means of sharp-edged weapons. Third paragraph he says, at that time Gagan arrived at the spot, asked his father Divya Singha regarding the incident. Divya Singha in murmuring sound replied something to said Gagan, which I could not heard. And then he says that they were taken in ambulance, my lords. He is also a witness to
your submission that Pagal did not make any dying declaration, but this line.
No, my submission before your lordship was, in the ambulance, Divya Singha has made the dying declaration. So far as Pagal is concerned, he has made the dying declaration at the spot.
Okay.
Now at cross-examination, my
What
lords,
happened to these accused persons who have been named as the assailants? That is, any of them have been released on bail?
no.
Okay. What are the injuries sustained by the deceased?
Yes. Injuries, your lordship may look at the evidence of PW 26.
He is the doctor.
Yes. PW 26, Assistant Professor, Department of FMNT. Paragraph 2. Paragraph 2 relates to Pagoda alias Kulamani. Rigor mortis absent in the neck, present in all limbs. Postmortem lividity found on back of the body. Fixed vein flong found attached to the body. Face deformed, dried blood sticking to it. External injuries. Cut wound of size 5 cm into 2 cm into skull deep, present on frontonasal junction of the face. Cut wound size 4 cm into 1 cm into skull deep, present obliquely on left temple, adjacent to the outer canthus of eye. The next is a superficial cut wound on the right nasal bridge. The fourth is a lacerated wound on the chin. Fifth is an abrasion on the right shoulder tip. Sixth is an abrasion on the right flank of the abdomen. And then multiple abrasions on the toes of the right foot and abrasion in the middle of the 1/3 right forearm. Internal findings are paragraph 4. Under surface of the scalp found contused on right frontal and temporal area. There was depressed comminuted fracture of the skull involving entire frontal bone, corresponding external injuries 1 and 2. Frontal bone fractured into pieces. Mandible found fractured. The lordship will note the jaw is found fractured. Below external injury number 4. Coronal and Sagittarius sutures were found separated. Diffuse, subdual and subarachnoid hemorrhage found over both hemispheres. Internal organs intact but congested. Opinion is external injuries 1, 2 and 3 with corresponding internal injuries, antemortem in nature caused by moderately heavy to heavy cutting weapon and fresh in duration at the time of death. Then paragraph 7 relates to the other disease.
All right. What is your submission? Ajay, find
my submission, my lords, is
yes.
that with the injuries that have been found, including the fracture of the jaw, this man would not have been in a position to say.
How can I give a finding on those aspects?
No, I am not asking your lordship to give a finding.
Yeah.
I am only submitting, my lords.
Yeah.
Then the other person's injuries, my lords, will be at paragraph 8, my lords. Paragraph 9. External injuries are chop wound of size 11 cm into 1 cm into brain deep, present on the mid-parieto-occipital area, on the vertex, starting from the left parietal area, 3 cm lateral to midline, ends on the right side occipital area, 5 cm below parietal eminence. Second injury is a cut wound 6 cm into 3 cm into bone deep, present on the back of the middle, 1/3 of left arm, with a tailing on its inferior border, with compound fracture of humerus. The third injury, my lords, is a cut wound on the left knuckle adjacent to the index finger. Fourth is an abrasion on the forehead. Fifth is abrasions on the back of the abdomen. Internal findings at para 10, skull and dura found cut underneath external injury 1. Left side parietal lobe of brain found lacerated. Diffuse subdural hemorrhage found over both hemispheres. Lords may look at para 14 of his evidence.
Whose evidence?
This doctor. Cross-examination. Para 14.
Doctor is PW
26. In the middle of the paragraph, my lords, the sentence begins considering the nature. Considering the nature of injuries sustained by the above named deceased, amount of loss of blood, location and size of injuries, their advanced age, they could not have been in a position to speak. Similarly, they may or may not have been alive for more than 10 to 15 minutes after sustaining the injuries. And the last sentence of that paragraph, he has said, it cannot be said with absolute terms that state of mind of deceased in such scenario would not be proper and balanced. Lords, my submission, again your lordship may turn to paragraph 19, my lords. He has denied my suggestion that a person would be clinically dead immediately after sustaining the nature of injuries reflected in the PM reports and would not be in a proper state of mind to talk. In any event, these are the injuries. And the witnesses, my lords, to this dying declaration, they have all been examined in the meanwhile. Their evidence, my lords, I would say that the evidence of these witnesses is not consistent, my lords. Varies from person to person. Even then, I am not asking your lordship to go into a finding on that.
They have named all these two persons.
The same thing, my lords. Parrot like this entire statement.
7, 8, 9, 10, 11, all have stated
yeah.
along with the others.
Yeah.
Yes.
My submission, my lords, before your lordship is, petitioner before your lordship is an 80-year-old man. He is in custody now from January 2021.
Okay. Yes.
Nature of evidence is only this oral dying declaration. Allegedly stated before persons who are known to them, either relations or persons with whom they have a political affinity, my lords. Each of these witnesses in cross-examination admits that there is political rivalry between the accused persons and the deceased, my lords. They also admit, my lords, that each of them has been involved in certain cases along with the witnesses, my lords.
Oh, how many cases are there against this?
Yes, ସମସ୍ତଙ୍କର ମୁଁ ଲେଖିଛି ସେ ଯୋଉ ଡେଟ୍ ଚାର୍ଟଟାକୁ your lordship may look again. Second page, so far as PW7 Rusingo Ojha is concerned, at paragraph 16 of the cross-examination, he has admits being accused with informant Ramakanta and others in 2 criminal cases and facing trial. The next witness, PW8, Manoranjan Mahapatra, my lords. He has admitted at paragraph 4 of his cross-examination implication in 2 criminal cases, but says, I cannot say if the deceased Kulamani, Ramakanta and Ranjit are co-accused with him. But he says that accused Bhikari lodged an FIR against him in 2017, for which he is facing a trial, and also a witness in a criminal case initiated by Ranjit against the accused.
So against each of these 2 petitioners, Mola and Lalit, there are 2 criminal cases.
Right.
Against Malayo Miller, there is 1 criminal case is pending, except this Miller.
Against me, there is 1 criminal case.
My London senior is saying that against PW 7,
This
8,
is
9 and 10.
witnesses, my lords, against the witnesses.
So, no, but so far as the petitioner is concerned, 1 criminal antecedent.
1 criminal antecedent.
And against Lalit also 1 criminal.
Yes. 506 and some minor.
Yes, what is your submission, Mr. Nayak?
Millard, the same footing Millard, I am standing Millard because the post occurrence witnesses Millard 7, 8, 9, 10 Millard.
No, he says about the 8 years old and this custody, perhaps he has completed 3 years.
Millard, the same Millard. Here we also Millard, the petitioner is aged about now Millard 43 years Millard. And custody Millard same
His
period.
custodial period is a fortnight less.
Yes, what do you say? What is your submission?
Lords, even though PW6 has not stated about the dying declaration in the ambulance, still, my lords, it's fine.
No, is it that even though there are total number of witnesses are 53, na?
59.
59. 59 out of 59, 31 have already been examined.
Lordship.
The rest have been declined.
And rest declined, only the IOS
Yes.
that examination is continuing.
My lords.
So, so that means you are the last witness is examined now. So at this stage, there is no chance of tampering with the evidence, and they are in custody almost 3 years. One has already crossed 3 years, another is. So merit, we are not entering into the merit at this stage, because prima facie case is one thing, but the 2 other things which are required to be considered is about chance of absconding, tampering with the evidence. So tampering in this case
Doesn't arise.
doesn't arise. And absconding, they must be the permanent resident of their.
Yes.
So what is your instruction? If
I am a retired government servant.
they are released on this at this stage, what in what way the your case will the prosecution, the trial will be hampered in what way? They are the local residents and they are in custody for 3 years. Every witnesses have been examined. Whether the evidence is to be accepted, not accepted, dying declaration notice. Those are the things which has to be taken care of by the Lenient Trial Court. Once I give any finding, that would, because detailed documentation, it should not be done.
In fact,
So-
we are also not insisting on
So
that.
that is what is, one is that age, the other factor is the detention period. Third factor is all the relevant witnesses have been examined. Last witness on behalf of the prosecution is going to be examined, or is the examination is continuing.
It's continuing.
I leave it at your lordship discretion.
Are the Lenient Counsel for the petitioner, good or common court? Are Mr. Devasis Pandal and counsel appearing for the petitioner Lalit Kumar Bara and Mr.
Lalit Mohan.
Lalit Mohan Bara and Mr. Biswajit Naik, Lenient Counsel appearing for petitioner Malay Kumar Bara. The Land Council submit that the petitioner, Mr. Panda submit that the petitioner Lalit Mohan Baral is aged about 8 years and he is in custody since
5th January
5th January
2021.
2021. So he has completed 3 years in judicial custody. And so far as petitioner Malaya Kumar Barik is concerned, Mr. Nayak submitted that he is in custody since 20 to 1 2021. Both the Land and Council submitted that out of 59 charge sheet witnesses, 31 witnesses have already been examined. And the rest, and the investigating officer is the last witness on behalf of the prosecution whose examination is going on, and the rest of the witnesses have been declined. And there are no eyewitnesses to the occurrence. The case mainly rests upon the oral dying declaration stated to have been made before PW 7, 8, 9 at the spot, and 10 and 11 in the ambulance, in which both the deceased were shifted to the hospital. It is submitted that at this stage, since there is no chance of tampering with the evidence, and since the petitioners are permanent residents of their village, there is no chance of absconding. The bail application may be favorably considered. Land Council for the state submitted that witnesses to the dying declaration have named the petitioners, so also the other co-accused persons to have participated in the assault of the deceased person. Since detailed documentation on the merits of the case is to be avoided while considering the bail application, and the Land and Trial Court is to adjudicate at the appropriate stage whether the evidence relating to the dying declaration would be accepted or not. It would not be proper on my part to give any finding on those aspects. Our taking into account the stage of the trial, age of the petitioner Lalit Mohan Baral, the period of detention of the petitioner in judicial custody, and since all the material witnesses have been examined and now the investigating officer's examination is under progress, I'm inclined to release the petitioners on bail. They will appear before the trial court on each date and the case should be put.
Obliged. Item number 3. Lordship, item 3 kindly taken up for 2 weeks after. Item 3.
Interim bail, what purpose you are filing? On what ground you are seeking for interim bail? अरे आपन interim bail application कौन पे file करछन्ती?
Honorable Council.
Mr.
Miller.
Interim bail कौन ground कौन?
No, last occasion, my lord. Yes, 5 for interim bail is allowed for a period of 4 weeks, my lord.
But no, 582 or interim bail.
24/11/23 order, my lord.
केबे?
24/11 I.
This is that is yes. Subsequently, you are being granted interest. So it is an earlier application pending, interim bail application. So now this application you have to argue on merit of this, right?
Yes.
So IN number 582 of 2020. This is an application for interim bail. Since subsequent application filed by the petitioner for interim bail has been allowed and he has been granted interim bail for a period of 4 weeks in IN number 1476 of 2023 as per order dated 24/11/2020. This bail application is not placed. The Land and Council for the petitioner seeks for an adjournment. Mr. J.P. Patra, Land and Special Counsel appearing for the state of Orissa in UPIDF matter is present. Put up this matter. You want adjournment for 1 week or 2 weeks? 2 weeks. 2 weeks, sir. So list it in the week commencing from 26th of February 2020. Yes.
Obliged. Item number 4.
May I please, Lordship? And this is a case under section 458, 395, along with 25, 27 arson and 3 and 4 Indian explosive arms, my lord. And the petitioner is in custody since 25/5/2020.
First application or earlier rejected?
It was earlier rejected, my lord.
So what is the number?
I have given the number, my lord.
नाला झुलिया alias धनेश्वर लेंका आपनकर आगो बेल एप्लिकेशन नंबर केते आ कोन ऑर्डर हेइथिला
ଏଇଟା ଆଗରୁ ମୁଁ ତ ଦେଇନି କିଛି ନମ୍ବର।
No, it is BLAPL number 3912 of 2020. So it was withdrawn. As it appears. 3912 छोड़ा और किसी फाइल कर लेगी। No. All right. So now you are in custody since when?
25/5/2020, my lord.
What are the offences under which charge sheet submitted?
My lord, 458/395 along with
458/395
along with my lord 25 Arms Act and 3 and 4 Explosive Substance Act.
3 and 4.
Yes, sir.
So what materials are there against you?
My lord, the petitioner being implicated by the confessional statement of co-accused.
Yes.
But my lord, he was identified in the TI period, my lord. And so also in 2 of the witnesses has been identified the present petitioner in the dock, my lord. But my lord, similar footing, 2 of the co-accused persons, my lord has granted, who was also identified in the TI period.
Who are they?
My lord, Gadadhar Naik and Pradeep Jena. And they are also, my lord, identified in the TI period.
So, Mr. Mishra, is it correct that the petitioner stands on the similar footing like the co-accused Gadadhar alias Dasarathi Naik and
Yes, Lordship,
Pradeep
stands on
Jena
similar footing.
are the learned counsel for the petitioner and counsel for the state? Considering the submission made by the learned counsel for the petitioner that the petitioner is in judicial custody since 25/5/2020, he has been charge sheeted under section 458/395 of the Indian Penal Code, 25 of the Arms Act, section 3 and 4 of the Explosive Substances Act, and similarly situated co-accused persons Gada alias Gadadhar alias Gandharva alias Dasarathi Naik and Pradeep Jena have been released on bail in BLAPL number 8668 of 2022 and BLAPL number 12308 of 2022 as per order dated 13/4/2023 respectively. And the submission which is not disputed by the learned counsel for the state after verifying the case records, also the deposition of the identifying witnesses. I am inclined to release the petition on bail allowed.
My lord, item 15 similar co-accused. My lord. Item 15 similar co-accused. 15 my lord, 15. BLAPL number 4361/2023.
15 टा कौन देखिले Mr. Tripathi?
Yes, same.
Same footing.
Yes.
All right. Allowed next.
Obliged.
And what is the date of custody?
Custody my lord से 2000 में से रहला है 1/7/2020
सेटा जो सेकंड टा बाकी सब समान रखिबे 15 नंबर टा खाली कस्टडी टा कर देबे 1/7/2020 तो
my lord.
ओके यस
Obliged.
Item 5.
I can take no 1 week after my lord. I had some documents.
You have received the case diary?
Yes, case there is there.
Learned counsel for the state summit that you have received the case diary. Mr. Patnaik, you are for the informant.
For the company.
Mr. Patnaik appears for the informant company.
Yes.
Informant company. Learned counsel for the petitioner seeks for an adjournment of this matter. We commencing from 26th February 2020. Yes.
Item number 6.
May I please, Your Lordship? My Lord, this is the successive bail application of the present petitioner. Earlier, my Lord, first, my Lord, BL appeal 6110 of 2021. It was order was passed on 9/1/2023.
No, what is that order copy?
My Lord, that
What is this 7250 which has come?
that-
Johan Maji is another person.
my Lord. They are the co-accused persons, my Lord. They have already released on bail. Here, my Lord, that alleged offense under section 20B2C and 2529 of the NDPS Act, my Lord. And here, my Lord, the present petitioner is in custody since 24/8/2020. And then, my Lord, charge sheet has already been filed on 3/3/2000.
24/8/2020.
My Lord, 24/8/2020.
Okay.
And my Lord, charge sheet has already been filed on 3/3/2021.
No, it's all right. But what is the stage of this?
Stage, my Lord, out of 34 charge sheet witnesses, 7 witnesses has already been examined.
Status report has been
Yes, my Lord, status report was called for.
What is that? Hey, status report on who order age?
Previous order, my Lord.
Status report of see.
And for the another
Wait, just no status report as for and rather an order was passed that this man is from UP.
Yes, my Lord.
And
Lordship.
whether the address furnished in
We're
the
yet
court-
to receive that instruction.
all right, get it, and also I'm calling for the status report.
Lordship.
The Learning Council for the state submits that as for order dated 14/12/2023 is yet to receive instruction
My Lord.
regarding whether the address furnished in the cause title is correct or not.
My Lord.
Land Council for the petitioner submitted that the petitioner is in judicial custody since 24/8/2020, and he has instruction that out of 34 charge sheet witnesses, 7 witnesses have been examined so far. Let a status report be called from the
my Lord.
trial court.
My Lord, my humble submission, my Lord, in the connected case arising out of the same case, same year, a status report was called for, and that order, your Lordship was pleased to pass the order, and
because it is to be urgent, he has not received it. Yes, next.
Item number 7.
Yes, item
Yes,
7.
my lord. This is the third application, my lord. In the first 2 applications, the order sheets I am passing.
You have received the case diary?
Yes, my lord.
What is the offense here?
My lord, 20B2C of the NDPS Act.
So you are custody since?
My lord, 23rd/12/2020.
How many witnesses have been examined?
My lord, 13 out of 18, my lord. The status report is at flag G, my lord. Flag G.
Thank you. He is expecting the case to be disposed of by end of first quarter of 2024. So, what about the criminal antecedents?
Nothing adverse against him except this.
So let that lady go on interim bail. The
My lord.
person number 2 is a lady.
Lordship.
Okay. Are the Learning Council for the petitioner, Learning Council for the state, considering the submission made by the Learning Council for the petitioner, that the petitioner number 2 is in judicial custody since 23/12/2020, and she is a lady, and out of 18 charge sheet witnesses, 13 witnesses have been examined as per the status report furnished by the Learning Trial Court, and that she is a local person. There is no chance of absconding. in view of the commercial quantity of ganja seized while not inclining to release, and bar under section 37 of the NDPS, while not inclining to release her on bail on merit, but taking into account period of detention, 3 months bail granted. And so far as number 1 is concerned, in view of so and so stands rejected. Commercial quantity 37. Yes. Rejected. P1 rejected. P2, 3 months. Yes, next.
Item 8.
Mr. Rakesh Kumar Das. CD available?
Yes, CD is there.
Right, pass over next.
Item 9.
May I please, Your Lordship? Offense under section 302, 201, 120B.
Earlier application rejected.
My Lord.
What is that order? Which application? Your last bail application?
8666 of 2020, my Lord.
8666 of 2020.
20, my Lord.
It was rejected on
By my Lord.
22/6/2021. So since when you are in custody?
I am in custody from 20 September 2020.
Charge sheet under section?
Under section 302, 201, 120B. IPC
302, 201.
My Lord.
120B.
My Lord.
Then?
There is section 25, 1B, A, 27 Arms Act.
So what is the stage of trial now? You are not aware?
Not aware. All the co-accused persons released on bail.
I'm asking you a question. You should know that what is the stage of trial, because you are in custody for more than 3 years, whether trial has commenced or not, how many witnesses have been examined, and if examined, what they have stated against you. All these things are required to be considered.
I have no role in this case, man. Only
that it can be only ascertained when I see that what is the stage and what evidence has been adduced against you, because your bail application has already been rejected. So we want a change in the circumstance. So that can be ascertained only if trial has commenced, witnesses have been examined, and what evidence has been adduced. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 29/2020. And last time when the petitioner approached this court for bail in BLAPL number 8666 of 2020, same was rejected as per order dated. No, same was dismissed as withdrawn as per order dated 22/6/2021. When a query is made to the learned counsel for the petitioner regarding the status of the case, he is unable to say clearly about the position. Learned counsel for the state has received the case diary. Let a status report be called for, matter be placed before so and so, put up this matter. If any witnesses have been examined, in the meantime, the learned counsel, learned trial court shall send the Xerox copy of the deposition of all those witnesses to this court. Yes.
Item 10.
Mr. Jafrullah, earlier application rejected. What is number?
checked, my lord. And this is the second journey of the petitioner. Earlier bail application number 4666 of 2023.
Earlier application was rejected.
My lord, rejected it.
That is 4666.
4666 of 2023 disposed of on 6/2/2023.
Yes.
My lord. And he is in custody since, my lord, 13th May 2022, my lord.
Status report was called for.
Out of 15 charge sheet witnesses, 7 witnesses have been examined. And the case was posted to 5/12/2023 for hearing. This is the status report dated 24/11/22. So what happened on 5?
In between, one witness have been examined, my lord.
So that means 7 plus 1, 8.
Eight witnesses have been total examined.
And you were in custody since when?
13th May 2022.
13th May
2022.
2022.
My lord.
No.
Local person, my lord.
No, 1 year. Not that is inordinate delay. And he is asking to dispose of by second quarter. You move after second quarter. Peruse the status report furnished by the learned
My lord, may I supply another
24/11/2023
copy of the witness?
from which it appears that out of 15 charge sheet witnesses, 7 witnesses have been examined by the prosecution, and the case is expected to be disposed of by end of second quarter 2024. And the case was posted to 5/12/2023 for trial. Learned counsel for the petitioner submitted that on 5/12/2023, one more witness was examined. The earlier bail application of the petitioner in BLAPL number 4666 of 2022 was rejected as per order dated 6/2/2023, taking into account the seizure of commercial quantity of ganja and in view of the bar under section 37 of the NDPS Act. Considering the submission made by the learned counsel for the respective parties and the progress of the trial and the seizure of commercial quantity of ganja and bar under section 37 of the NDPS Act and the status report furnished by the learned trial court, while not inclining to release the petitioner on bail, if the trial is not concluded by the second quarter of 2024, the petitioner is at liberty to renew the prayer for bail disposed of. Yes.
Obligers.
Item 13. Item 13 and 17 arising out of same case.
Yeah, kuda.
Item 13 and 17.
13 and 17.
17. Both arising out of same case. And in the meantime, after conclusion of trial, both have been acquitted.
The learned counsel for the petitioner submitted that the matter has become infructuous as the trial has been concluded and the petitioner has been acquitted. So, Seta, which is Satra number. Yes, next.
Item 14.
May I please, my lords. Charge sheet filed under section 372F1 and 506 IPC with reduced POCSO Act, my lord. Petitioner custody, my lord, since 27/4/2007.
रमेश चंद्र महाराज पासो सीडी अछि तो
Yes, my lord.
ओके पासो
Item 18.
18 Mr. Das
Item 16, my lord.
16 पासो अच्छा ये डाकी जंतु 16
16th.
हाँ जोड़ा पासो वर्ड जो होता है से आसले यस
Item 16.
May I please, your lordship? My lord, the present petitioner initiated custody, my lord, 24/11/2020, my lord. And offense, my lord, 420, 406, 409, 467, 468, 471, 379, 120B, 34 IPC, my lord. Here, my lord.
एडा पर से जो केसटा जो
Yes.
हां हेडा केबे अछि सेडा गुटे
सेटा आरो सप्ताह अछि
एई जो लाला अमृत ता संग रेडा रखी जम से एडा केबे रही छी जम हला लेखि जम तो से दे देबे नंबर ओडा of this matter along with one yes next
Public.
Item 18.
Last occasion, lordships call for a report order dated, my lord, 1/9/2023, my lord. कोई क्यों जे लॉर्डशिप में kindly apply this honorable court.
no you are never released on interim bail
No, my last bail was, my lord, rejected on 21/10/2022.
in BLAPL
609/2022
काई से ऑर्डर काई
order टा एडा transfer brief
2022
आइए that is available in website, my I have examined, my lord, some of the co-accused are released on bail, my lord. The petitioner granted liberty to file there in trial court. That is the order.
21/10/2022 रे अपन इलेक्शन एटा बाहर कल कोन है ऑर्डर टा देख 609 BLF 609 2022 संतोष ଅର୍ଡରଟା ବାହାର କର 21/10/2022 ର ଅର୍ଡରଟା ବାହାର ସେୟାର କର ସେଟା ଆସିଲା
ବଡ କର ଆଉ ଟିକେ ବଡ କର ଆଉ ଧର ବଡ କରିଦିଅ
ଠିକ ଅଛି this for withdrawal ଅଛି ନା
ହଁ we are liberty to file a development one of the co-accused released on a term of release course.
So you are in custody since when?
Or 18/9/2017.
Is it that date is correct?
Yes, two person caught from the spot. One is granted bail. This is another.
This Dolamani Bhagarti is that other person.
Yes, one is Santosh Datta, this petitioner, and
Apprehensions from the spot.
You are a man from
local one.
Okay, are the land counsel for the petitioner, land counsel for the state, land counsel for the petitioner submit that the petitioner is in judicial custody since 18/1/2000.
18/9, my lord.
18/9/2017. And when this petitioner approached this court last time for bail in BLAPL number, ऐसे number टा कितने थे?
609/2022.
609 of अरे अभी तोड़ू
नहीं तोड़ू हाँ
हाँ
out 609
9 of 2022 by virtue of order dated 21/10/2022 the same was withdrawn in order to move the trial court. It is further argued that similarly situated co-accused Dolamani Bhagarti, who was also caught at the spot and taken into judicial custody, has been released on bail in BLAPL number 7565 of 2022 as per order dated 13/4/2023. He files the copy of bail order of the co-accused which is taken on record. Land counsel for the state doesn't dispute that the petitioner is similarly situated like the co-accused Dolamani Bhagarti. In the case of जो डिसीजन टा लिखा है मोहम्मद मुस्लिम सेटा कोट कर देगा है ना considering the submission made by the land counsel for the respective parties, keeping in view the period of detention of the petitioner in judicial custody, the release of the co-accused, similarly situated co-accused on bail, and the ratio laid down in the case of Mohammed Muslim alias Hussain, I'm inclined to release the petitioner on bail. Huh? Yes.
Oblige.
Item 20. May I please your lordship? On behalf of Pavitra Kumar Paik, lordship. Lordship, in the last date we filed an IA, lordship, for interim application, interim bail of the petitioner. Your Lordship allowed that I and direct us to file the consolidated petition, Lordship. We filed that consolidated petition, Lordship. And another co-accused released on bail, Lordship, by Honorable Justice Didas, Lordship.
No, you are moving an interim application for bail or on merit you are facing this matter?
Lordship.
ଆପଣ ଏଇ ଯୋଉ ବର୍ତ୍ତମାନ ମୁଭ କରିବାକୁ ଚାହୁଁଛନ୍ତି କୌଣସି
Yes,
ଇଣ୍ଟରିମ୍
interim bail,
ଆପ୍ଲିକେସନ
Lordship.
ଫାଇଲ କରିଛନ୍ତି ଇଣ୍ଟରିମ୍ ବେଲ୍ ପାଇଁ ନା
Yes, Lordship.
what is
Your
that IA number?
I number 1068 of 23.
ଏଇଟା ଆସିନି କାଇଁ ଲିଷ୍ଟ 1068
Yes,
Lordship.
And 1068 ଲେଖା ହେଇଛି କଣ for an application for correction of the cost
Consolidated
title
petition was filed at consolidated petition. Lordship.
correction of cost title.
ହଁ ସେଇଟା ତ ଗଲା ସେଟା ଅର୍ଡର ହେଇଗଲାଣି ତା ଉପରେ
No, Lordship.
ଓହୋ One 1068 2023 ପୁରା dispose of ହେଇଗଲାଣି
Yes, Lordship. Dispose of
correction of the cost title after going through the interim application so and so the prayer is allowed and you are directed to file a consolidated copy of the petition incorporating the details of the LA so and so. So that is over. Now you have filed the consolidated application.
yes, Lordship.
So देखिले consolidated application अच्छी काहीं
Lordship, another co-accused is released on bail, Lordship.
wait
Lordship.
it's a commercial quantity of ganja seized. So your last bail application you are in custody since when?
Lordship, 16/8/2020.
16/8/2020.
Lordship.
So you are mainly taking the ground of your wife's ailment.
Yes, Lordship. She is suffering in pelvic inflammatory disease, Lordship.
What report you have got, Mr. Tripathi? Verified the sickness of the wife, undergone treatment at CSC Chandragiri in so and so. Okay, subsequently she has been referred to some on my local document verification for dissection. Oh, your bail application before the trial court was also for the same reason, that wife's ailment.
Lordship.
He is a local man, Rajapati. All right, heard the learned any criminal antecedent?
No criminal antecedent.
Heard the learned counsel for the petitioner, learned counsel for the state. What is your good name?
Sisir Paningrai.
Mr. Sisir Panigrahi submits that the petitioner is in judicial custody since 16/8/2020 and he has filed he is seeking for the petitioner is seeking for interim bail on the ground of ailment of the wife of the petitioner. Medical documents have been annexed to the application. The learned counsel for the state was asked to obtain instruction. And today he has produced the written instruction received from the inspector in charge of Mohana police station. এটা ওটা পুরোনাটা
ସେଇ ଦିନଠୁ ଅର୍ଡର ହେଇଛି ତାପରେ ପରେ ଆସିଲା 7/7 ଅର୍ଡର ହେଇଛି
ଏଇଟା ହଉଛି ଆପଣଙ୍କର 28
28/7
7 ନା 4?
7/7 2023 ରେ ଅର୍ଡର ହେଇଥିଲା ଇନଷ୍ଟ୍ରକ୍ସନ ଅନ୍ ମେଡିକାଲ।
ଆଚ୍ଛା, which indicates that the wife of the petitioner was treated at CHC Chandragiri, and then she was referred to MKCG Medical Hospital, Berhampur. The written instruction is taken on record. Considering the submission made by the land council for the respective parties, the amendments taken in the application, the medical documents annexed, and the written instruction obtained, while not informing to release the petitioner on bail on merit in view of the commercial quantity of ganja seized and bar under section 37 of the NDPS Act, I am inclined to release the petitioner on interim bail for a period of 1 month from the date of release, while interim bail will appear before the London trial court on his date and shall not try to tamper with the evidence. Yes, next.
Lordship, 2 months email. Lordship.
Yes, next.
Item 21. And the petitioner is in custody since 8/12/2022, my lord.
You have received the case diary, Mr. Earlier bail application rejected.
No, no.
Okay.
A co-accused person has been
Just a
already
minute. it is stated at the bar that 19 witnesses have already been examined.
Yes.
Yes, including the victim. Yes.
I may also renew prayer thereafter.
The petitioner is at liberty to renew the prayer. Yes.
Oblige me.
Item number 23.
Mr. May please yourself. Dita ko ye kariye. Yes, item 23, Mr. Sahu.
May please yourself.
Surrender certificate not received.
You will see that petitioner has not surrendered in time here also.
So now he is absconding.
Yes.
The learned counsel for the petitioner submitted that though the petitioner was granted interim bail as per order dated 4/8/2023 in IA number 748 of 23. For a period of 1 month, but after availing the same, he has not surrendered in the court below, for which the surrender certificate could not be filed. Since the petitioner has flouted the terms and conditions of the interim bail, I'm not inclined to entertain this application. Accordingly dismissed. The London trial court shall take necessary steps for arrest of the petitioner. Henceforth, if the petitioner moves an application for bail, this particular order shall be brought to the notice of this court. Yes, next.
Disposal matter. My lord, I may pardon, my lord. The connected matter may same order may be possible.
Yes, sir.
My lord, in item 21, in the trial court there is a 5th February की posting है.
5th February.
है.
5th February next date है. All right. अच्छा honor before कर दियो अंदर. साजियला 2 तारीख 21. Honor before 8th कर दियो गोटे सा. 8 पर जो 5 पर जो date रहेगा से आने प्रदेश कर. Yes, next.
Item 24.
24, my lord. 20B to C of NDPS Act. And let us call for the status report.
Status report.
Local man.
Status report first quarter of 24 रे साथ देवा कोई जानी. Out of 20 charge sheet witness, 7 witnesses have been examined. Expected to be disclosed.
81-21 को सर local man अपने interim bail.
How केटा case अच्छी NDPS रा.
One gote
अच्छी.
NDPS. Commercial quantity.
Yes.
The London count review the status report, in which the London trial court has mentioned that the case is likely to disposed of by the end of first quarter of 2024. The petitioner is at liberty to renew the prayer for bail if the trial is not disposed of by the said period. Accordingly, bail application is disposed of. Yes, next.
Item number 25.
May I please, lords? Last occasion, your lordship call for the status report, my lord. The petitioner is in custody since 19/5/21.
Four witnesses have been examined out of 18.
18, my lord. Slow progress of trial, my lord. The last occasion, your lordship directed to release the petitioner on interim bail and that ground, my lord. So slow progress of trial and
When you are granted interim bail, which application?
interim bail granted on 5/1/60 of 21, my lord, BLAPL. He was released on interim bail on 27/1/23 for 3 months. Surrender on 6/5/23 in time.
Mr. Das, earlier he was granted interim bail. Surrender at right time. Now status are the London counsel for the petitioner, London counsel for the state. London counsel for the petitioner submitted that the petitioner was taken into judicial custody since 19/5/2021. And taking into account the delayed disposal of the trial, he was directed to be released on interim bail for a period of 3 months, as per order dated 27/1/23 in BLAPL number 5160 of 2021. And after availing the said period, he surrendered at right time. Status report furnished by the London Trial Court indicates that out of 18 charge sheet witnesses, 4 witnesses have been examined. Status report dated 15/12/2023. Considering the submission, slow progress of the trial, conduct of the petitioner in complying the earlier order of interim bail, I'm inclined to release the petitioner on interim bail for 3 months. Disposal. Yes, next.
Item number 26.
Submitted under 302. Last bail application was disposed of on the rejected on the ground of the in account of the eyewitnesses, and I am giving the copy of the FIR. All the eyewitnesses have been examined and a kind of glance to the
Examined in the trial court.
I have annexed the judgments, my lord, and the depositions. All have, my lord, not stated anything. So also annexed to the petition.
Mr. Das, he said that the eyewitnesses have been examined in the trial court and they have not supported the prosecution case.
If 6 persons of the eyewitness,
Let it be taken up to, next week, madam. Okay, Mr. Das, Land Council's
since
for an
2021 he's in
adjournment to next week to verify the statements of the deposition copy supplied by the London Council for the petitioner along with the bail application as to whether any other material witnesses are left out to be examined or not.
Seventh. Seventh question.
7th. 7 we commencing 5th ratio. According 5 to Jodhina Japadi. Yes, next.
Item 11, Milord, the IS is in virtual mode.
Item 11. Where is Mr. Mahanti?
The victim
Yes.
My lord, petitioner in custody since 14/1/18, my lord. In the meantime, 6 years have been passed.
14/1/2018.
2018, my lord.
You have never been released on
No,
interim
I
bail.
have released
Then
3 months.
how many times you have been released?
3 times, my lord. Even that has been included. This is more than 5 years.
When you are released on bail last time?
Last time I have released on bail on in BLAPL number 3481 of 22 on 8/7/22, my lord. And almost
Now, what is the stage of the trial?
trial is out of 24 witnesses, most probably 18 or 19 witnesses have been examined, and your lordship has status report last time. Your lordship also asked for a status report, my
The
lord.
status report is dated 8/8/23.
My lord.
So,
and the co-accused, main co-accused, all the co-accused has been released on bail.
no,
my
no,
lord.
the status report indicates out of 24, 18 witnesses have been examined, but that is a report of August.
My lord.
So now we are in January 24. So what has happened in the meantime? Have you got the order sheet with you? Thereafter, what has happened?
My lord,
How many further witnesses have been examined?
my lord, there is still,
Because there is
that
no
very
progress,
order
my
in
lord.
there is
Charge
no
sheet is
progress.
one, so progress, yes, witnesses are police personnel. Here is the status report dated 8/8/2023, from which it appears that out of 24 charge sheet witnesses, 18 witnesses have been examined. The learned counsel for the petitioner submitted that the petitioner has been released on interim bail thrice, and after availing the same, he surrendered at right time. And he has instruction that after PW 18, no further witness has been examined. Since the counsel is not producing the certified copy of the order sheet, let a status report be called for from the Land and Trial Court. While submitting the status report, the Land and Trial Court shall specifically indicate as to whether, after availing the interim bail period, the petitioner has surrendered at right time or not on each occasion. Put up this matter in the week commencing from 19th of February 2020.
This particular date may be fixed, my lord.
Yes.
Why is in custody in more than 5 years, my lord?
Yes, item 29.
Item 29.
My pleasure. On behalf of Lalitandu Bhuya Miller.
Yes.
Here the petitioner is inside
Item 31.
May I please, my lord? The petition is in custody since 10/5/2020, my lord. 10/5/2020.
ଆଗରୁ ଯାଇଥିଲେ
ନା
interim
ଯାଇନି, ମୋତେ ଇଣ୍ଟରିମ୍ ଯାଇନି। କୋଉ ଆକ୍ୟୁ ଯାଇଛନ୍ତି, ମୁଁ ତା ଅର୍ଡରଟା ଆନେକ୍ସ କରିଛି। ପେଜ 25 ରେ କୋଉ ଆକ୍ୟୁଜ ବେଲ ଅର୍ଡରଟା ଆନେକ୍ସ କରିଛି।
status report କଣ ଆସିଲା 12 ରୁ 6ଟା। ତ ଲୋକ କୋଉଠିକାର?
ଲୋକାଲ ମ୍ୟାନ ମାନେ।
Yes,
Malkani.
Mr. Tripathi, local man, heard the land counsel for the petitioner, land counsel for the state. Considering the submission made by the land counsel for the petitioner, that the petitioner is in judicial custody since 10/5/2020, and out of 12 charge sheet witnesses, 6 witnesses have been examined, which would be evident from the status report furnished by the land and trial court, and that he is a local man, and taking into account the submission made by the land council for the state that commercial quantity of ganja has been seized, and in view of the bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but in view of the period of detention, 3 months bail granted, disposed of.
Obliged.
Item 32.
Item 32, I seek an adjournment to next week, Your Lordship.
Next week or a week after?
A week.
You have received the case diary? Yes, sir. CD available. S.K.MISHRA and counsel appearing for the petitioner. 6 for an adjournment. Put up this matter will commencing from 19th February 2024. Yes.
Much appreciated.
Item 33.
Please, Your Lordship. I let it call for the status report.
that out of 37 charge sheet witnesses, 27 witnesses have been examined. The learned counsel for the petitioner submitted that he is not having the deposition copy and the same may be called for from the learned trial court. In view of such submission, let the learned trial court send the deposition copies of all the witnesses examined so far, Xerox copy, to this court on or before 9th of February 2024, on receipt of which registry shall hand over a set of deposition to the learned counsel for the state as well as to the learned counsel for the petitioner. Matter be placed in the week commencing from 19th February 2024. এই ଯୋଉ ଡେଟଟା କହୁଛନ୍ତି ଏଇଟା ଠିକ ତ? ଏଇ ଯୋଉ କଣ ଗୋଟେ କହୁଛନ୍ତି 15 ମସିହାରୁ ସେ ରହିଲାଣି?
ଚାର୍ଜ ସିଟ୍ ଅଛି
ମାନେ ବେଲେ ଯାଇନାହାନ୍ତି?
ନାଇଁ ବେଲେ ଯାଇନି।
ଆଚ୍ଛା, while the learned counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on
19/8/2015
19/8/2015 and till date he has never been released on interim bail. While submitting let a status report be called for, Allah. While submitting the status report, the learned trial court shall specifically indicate whether the petitioner has ever been released on interim bail or not. Allah? Okay.
Item 35.
Please, my lord. Here, my lord, the present petitioner is in custody since 1835.
CD available?
Yes, ma'am.
18/8/2017, my lord.
Just
More than
35. Custody date kebe?
18/8/2017. More than 6 years and 5 months.
2000 जमा जाई ना interim bail?
Interim bail several occasions, my lord. Page 39.
Custody रे कोई दूसरे status report आसिला 58 witness रू 29 witnesses have been examined.
No, it is not your case.
That
Sorry,
is
my
the
lord.
No, it is not his case. It is my case.
My lord. Oh, sorry, my lord. Mine was 36, my lord. I'm extremely sorry, my lord.
all right. Item number 35. This is 6924 of 20.
Yes, your lordship. He is in custody since 22nd of September 2017.
22nd of September 2017.
17.
And
he was granted interim bail. And in compliance with the interim bail, he duly surrendered.
When?
That interim bail was granted in December 2022.
In which application?
In BLAPL number 4727 of 2020.
Order copy achi. Have you got the copy of the order?
Soft copy.
I thought pass on kar do na. No. Why don't you pass on it today? Hey, then bahar karo jaha korte.
Yes, sorry, my lord. That hard copy also.
Pass on. It a last bail order.
Yes. And in due compliance, he surrendered. The status report has been called for earlier. By your lordship. Out of total 19 accused persons, all 18 persons have been released.
Technology 58 टा examination.
My lord. Except the present petitioner, all other have been released on bail.
So, are the learned counsel for the petitioner and counsel for the state? The learned counsel for the petitioner submit that the petitioner was taken into judicial custody on 22/9/2017. And last time when he approached this court for bail in BLAPL number 4727 of 2020, as per order dated 20/12/2022, he was granted interim bail for a period of
3 months.
3 months. And after availing the same, he surrendered at right time. And counsel produces the copy of the order which is taken on record. The status report submitted by the learned trial court indicates that out of 58 charge sheet witnesses, 29 witnesses have been examined. Considering the submission made by the learned counsel for the respective parties, slow progress of the trial, conduct of the petitioner in complying with the earlier order of interim bail, and his period of incarceration, I'm inclined to release him on interim bail for a period of 3 months. Yes, disposed of.
Other 18 persons have been released on a regular basis.
Next.
Item 36.
May I please?
Yes.
Here, my lord, the petitioner is in custody since 18/8/2017.
18/8/2017.
My lord.
How many times you are granted interim bail?
My lord, several occasions he has granted, that has reflected in page 39 of the rejection order, my lord. Earlier, he approached before this honorable court on 3 occasions, my lord. First was withdrawn. Subsequently, on the BLPL 7429 of 2019, he was granted 1 month interim bail. And in BLPL 9722, there also you got interim bail. And on each occasion, my lord, he surrendered on time, my lord.
So now this rejection order, which is dated 9/5/23,
My lord.
it indicates that out of 23 charge sheet witnesses, 10 witnesses have
My
been
lord.
examined. So thereafter, about 7 months have already passed.
Thereafter, my instruction is that one witness has been examined, and the informant is not turning up to adduce evidence. My lord. Available warrant.
Witnesses, my lord, he has given only up to 6.
6, my lord.
6 is the eyewitness, and 10 is also the eyewitness. Let him serve the deposition copy.
Deposition copy, I am having the certified copy. Later
It
on,
is not
up
available.
to 9. Yes, my lord. And
No, you provide him the Lawrence counsel
My
for
lord.
the state.
My lord,
He
my
has a right to go through them.
My
Not
lord.
that he will just pass on and
My
he will immediately argue the matter.
My lord, out of 6 is the relevant because 6 has supported the prosecution case. Other witnesses, they have not supported.
No, my lord. The rejection order shows PW 10 is also there. My lord.
10 টা নাকি?
Page 38, para,
The,
third para.
the rejection order dated 9/5/23 indicates that out of 23 charge sheet witnesses, 10 witnesses have been examined.
And it's a triple murder case.
And the Lawrence counsel for the petitioner submitted that only one more witness has been examined thereafter. And you are never released on interim bail.
My lord, several occasions, my lord, I have released on interim bail
And on some occasion, he has been granted interim bail, and after availing the interim bail period, he surrendered at right time.
My lord.
Right? Since the rejection order, since 8 months have already passed, date of rejection order, let a status report be called for from the Land and Trial Court. And while submitting the status report, the Land and Trial Court shall send the deposition copies of all the witnesses examined so far. Xerox copy, put up this matter in the week commencing from 19th of February 2024. Yes.
Next case, my lord, also arising out of same
case, same order. Adir out karibeni, eti khali kar debe, list this matter along with kar debe. 19/2/20.
In second one, my lord, only once the petitioner has granted interim bail. Second.
No, ଏଇଟା ତା ସାଙ୍ଗରେ ଆସିବ same case ରୁ arise କରିଛି ତ?
My lord, my lord.
Okay.
My lord.
Item 38.
Yes, 38.
Yes, my lord. Lordship, I am in this matter. Through this, my lord, on the last date of hearing, Lordship has sought report from the trial court. My lord, in this matter, I am in jail from 6/9/2020, and out of 65 witnesses, only 9 has been examined yet.
60. The trial court has reported that
out of 60
charge sheet witnesses, 10 witnesses have been examined.
Yes, my lord. I had the information of 9 only. So it may be 10.
Okay. Now
local man, lordship.
So
and
you what is the date of
arrest?
What is address?
Date of arrest? Date of arrest, lordship, 6/9/2020. 6/9. 2020.
Yes,
No,
he's a
no,
local man.
Local.
He's a local man, Lordship.
302 NDPS.
Huh?
302 and NDPS.
Uh-huh.
The driver 20B2C and 302 and CD is not available now.
When this, Lordship, in this matter, around 90% has been falsely applied.
Deposition copy, sir, will take up this matter next week. 10 witnesses deposition. He said that it is not only NDPS but also 302 case.
Yes, Lord. My Lord, in this matter, three or four accused has been on the interview by my Lord only. Seeing the
Right, you saw the deposition copy. The London Council, the period status report dated 3/11/2023 of the London Trial Court, wherein it is mentioned that out of 60 charge sheet witnesses, 10 witnesses have been examined. The London Council for the London Council for the petitioner supply the deposition copies of the 10 witnesses to the London Council.
Date should be fixed, Lordship, since the matter is not being taken up.
Who also seeks time to produce the case diary, put up this matter in the week commencing from 19th February 2024. Yes.
Item 39.
May I please, Your Lordship?
Yes.
The petitioner, along with others, they are implicated for commission of offense on section 302.
Is it the first application or earlier?
No. Earlier, twice the matter was before your Lordship.
Yes.
And once she was granted interim bail for a period of 1 month. In the mean period, what my information is that I have also supplied the copy of the deposition. Almost all the witnesses has been examined.
Status report was called for.
Status, your Lordship called for the
Status report is this. The prosecution has examined 37 charge sheet witnesses, including the investigating officers. Out of 51 witnesses, no charge sheet witness remains to be examined by the prosecution. Prosecution has declined to examine 14 charge sheet witnesses. The London Council for the accused, Prem Kumar Agrawal, has filed a petition to recall PW 34, namely Sheila Mittal, for further cross-examination. The petitioner has been allowed and the case stands posted to 10/1/24 for further cross-examination of PW 34. That is the report.
Sorry.
So,
and I will remind my Lord's attention that one of the co-accused who is similarly placed, he has been released on bail. That is
BLAPL number 3438 of 2020.
your Lordship dealt.
से जो डिपोजिशन कॉपी अच्छी तो
नहीं डिपोजिशन कॉपी ए केस रे नहीं
हाँ नहीं ये जो विटनेस मानकर डिपोजिशन कॉपी दियंतु ଆଉ ସେ ଯୋଉ ବେଲ୍ ଅର୍ଡରଟା ଦିଅନ୍ତୁ ଯୋଉ ସିମିଲାର
ବେଲ୍ ଅର୍ଡର ମୁଁ ଦେଇ ଦେଇଥିଲି
ବେଲ୍ ଅର୍ଡର ଅଛି
ଆଜ୍ଞା ତା ଦେହରେ your lordship dealt everything there is a dispute regarding a property
ସେ ଯୋଉ ଆପଣ ସିମିଲାର ଫୁଟିଂ ଦେଖିବାକୁ ହେଲେ
ହଁ ସିମିଲାର ଫୁଟିଂ
डिपोजिशन कॉपी ନାହିଁ ତାଙ୍କ ପାଖରେ ସେଇଗୁଡା
ଆର କେସରେ ଦେଇଥିଲେ
coming Friday, Mr. Mahapatra will bring this matter next Friday. You give him by Monday. You give just London Council the status report furnished by the London Trial Court dated 9/1/2024, from which it appears that after the closure of the after the examination of all the prosecution witnesses, a petition under section 311 CRPC was filed by the petitioner to recall PW 34, and the date was posted to 10/1/2024 for further cross-examination. Mr. Mahapatra and senior advocate submits that on that day the cross-examination is over, and he further submits that the petitioner is similarly situated like co-accused
Dilip
Kumar Sharma, who was granted bail in BLAPL number
3438 of 2020.
3438 of 2023 as per order dated
19/12/2023.
He has a copy of the bail order has already been furnished to the London Council for the state. However, he submits that he may be supplied with the deposition copies to verify the claim of verity. Put up this matter on 9th of February 2024. Deposition copy to be supplied by 5th of February 2024. Yes.
It is a case based on circumstantial evidence.
Okay, we'll see that. 9th February 2024. And this last one is that extension time allowed. Any passover matter? Huh? 8. 8 पूरा गला से जो पुलिस ऑफिसर गोटे कौन अपियर कला
सेटा 11 थिला
अच्छा अच्छा सेटा 11 नहीं मु
एटा नॉन
ये नहीं थिला से हां से 8 रे लिखि दबो सेटा हां तो कह देबो सेटा 11 से जो अपियर करथला ओके समन रिसीव करिवो विक्टिम को आनी पहुंचीबो हला ऑलराइट जो 8 एटा उडा कोन के अछंती नांती तो नॉन अपियर्स करिकिन अर्जन कर दियो आउ किछ अछि अर्जन ना